Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. Hello. Happy Tuesday. Happy Tuesday. Good morning, good afternoon, good evening, wherever you are coming in from around the world. I hope you're having a good Tuesday. I hope our week is going well so far. And if it didn't start out well, I hope it gets better. All right. We've got more trial updates. I know that this is basically what we've been doing on Tuesdays and Thursdays, is talking about Harvey Weinstein and Danny Masterson and getting our trial updates from articles for the Weinstein case, and basically almost, I mean, at this point we're basically getting it exclusively from Tony Ortega in the Masterson case, because he has just been doing such a phenomenal job of getting so much detail from the courtroom that it's like there's no point in going anywhere else at this point. He's done a fantastic job. And so with that, I decided to put in the description below, also pinned in a comment in the chat. If you guys want to, please do support him. If you guys are appreciating the Masterson coverage, subscribe to his channel. He's got a YouTube channel where he's posting all of these updates that we've been watching, we've been going through, and I've been commenting on. And he's also got a Substack that you can follow. You don't have to pay for it, but if you want the full access, you can pay for either monthly or annual access on his thing to help support him. So I highly encourage everyone to go and do that, because like I said, his information that we have been using has been so invaluable, and I'm so grateful for it. And it's, like we talk about this, right? Like when we're talking about the Weinstein case versus the Masterson case, it's like we kind of have to, like, I don't know, like maneuver a little bit, like kind of like keep things in mind for the Weinstein case, because it's like, well, I mean, how much of this is actually being filtered out? How much of this is being framed by the media, by journalists, because that has happened in previous cases before. So, if you don't exactly trust corporate media, like many of us don't at this point, it's we always kind of have to keep that in mind and not just like accept what the media is telling us. And especially when there are some noticeable gaps, right? Like we've talked about this before, how they haven't necessarily talked about cross-examinations of witnesses and all that kind of stuff too. But anyway, so wanted to talk about that. And before we get into the actual updates themselves, let's say hi to folks in the chat. All right, first off, Brittany Chanel, happy 22nd birthday. I remember yesterday you said it was your birthday eve. I'm happy that you're back today and we can celebrate your birthday together. So happy birthday. I hope you have a fantastic day. I hope it's lovely. Your second anniversary of your 21st birthday, as I like to say. So, you could do that a few years in a row. So yeah, happy birthday. And folks in the chat, if you're in, wish her a happy birthday, because that's awesome. That's awesome that she's spending her birthday with us today. Mary M, greetings from Munich, Germany. Greetings, guten Tag. Debbie Faison Cook, good morning from Florida. Good morning. Ophelia the Fair, hello from Austin, Texas. Pamela C, hello to all from Arizona. Joy Anna, good afternoon from Amsterdam. Happy election day for the Americans in the chat. that is also, thank you for the reminder. Today is election day. It's midterm elections. And regardless of what side of the political spectrum you come from, it is an honor and a privilege to be able to vote. So please do. Whether you are able to do so, I mean, by absentee, not to say that it's too late, but you usually want to get those in ahead of time. But if you're able to vote in person, please do so, because that, I mean, it's an awesome thing that we get to do as Americans. We get to have an impact. I mean, at least I hope so, right? um, have some kind of an impact. Some states more so than others, right? I mean, some of them are you kind of know what the outcome's going to be based on like how strong a political affiliation is in a particular area. But anyway, yes, please do vote. I don't care which side of the political spectrum you are from. It's just great to see Americans voting for what they think is right. Jessica Crago, good morning from Tennessee. Good morning to you. All right, let's see here. We've got some more folks in the chat. Those are the ones that I was able to save here, and we've got a lot of happy birthdays in the chat for Brittany. That's awesome. Okay, let's see here. We're gonna go through here. We've got, where else are people coming in from? Dafty Daff says morning from PNW. PNW. I'm not sure where that one is. Let me know, because that one is going over my head. I'm sure once somebody tells me in the chat, I'll be like, duh, of course. but welcome. Let's see where else we've got. Mary Ann Williams from Vegas. Good morning. Let's see here. We've got Marissa from the Netherlands. Welcome. Secret McSquirrel from Glasgow. Uncivil Law, Kurt, happy to have you in the chat today. Austin, Texas representing. Woot woot. Let's see. We've got Sunita Orr. Good morning from New Jersey. Thank you so much for saying my name right. As always, thank you for all your detailed coverage of these cases. Of course. And yeah, I'm always hoping that I'm getting everybody's names right, because I know what that's like, right? With a name like Alita, which is not even technically the Lithuanian way of pronouncing it. It should be Alita, but most Americans can't really pronounce that. So so I do an Americanized version. So it's there's a lot of confusion around my name always. So I completely understand. Anyhow, let's see. Courtney Greger from Temple, Texas. Welcome. Howdy. Okay, let's see here. Where else? We've got Nicole Christine from ATX as well, from Austin. We've got Mantha Johnny. Good morning from Montreal. Beautiful and sunny here. Actually, it's 24 degrees. Yes, Celsius. LOL. I have to admit, even living in a place where they use Celsius, my phone is still on Fahrenheit, and that's how I check the weather. So I still don't. I should know. I should know what 24 degrees Celsius is. I think that's warm, right? But to me, it's like it's a foreign language. Oh man, but welcome, Mantha Johnny. Happy to see you here again. And let's see here. Let's see. We've got Janneke Vandelaar. Hi from Netherlands as well. Happy to have you here. Chris's error. Oh, Pacific Northwest. Is that it? PNW? Oh, could be. Okay. Thank you for that. Okay. Yep. Pacific Northwest. Thanks, guys. Of course. Now that you say it, it makes perfect sense. Erica Knesick from South Carolina. Welcome. Stuck on Strings. Good morning from New Orleans. Just arrived. Well, welcome. Let's see. Oh, we've got Dale Ann Harsh from rainy Southern California. Well, Southern California always needs rain. And I always, as a Southern Californian, I always love seeing rain, even in places where it tends to rain. It just, for some reason, it still feels like a novelty to me. So I hope you're enjoying it. Let's see. And we've got, let's see. We've got Kiwi Twist Gaming. Good morning from Florida. Good morning. We've got Jennifer Jen, or J for Jen, for good morning from Oregon. PNW is the Pacific Northwest. Okay. Yep. So we've got confirmation, and Bethany Joe Chamberlain also from Portland, Oregon. We've got Lori Marie from Pennsylvania. B from Germany. Germany says, hi, how are you doing today? I'm doing well. How are you? I hope you're doing well. Let's see. Stephanie from Austria. Hello. Sue B from Ontario, Canada. An anime wholesale. Did LB go to Austin school? Yes, I did. I went to the University of Texas for law school, which is right there in Austin. Loved it. Fantastic experience. So many intelligent people that I was surrounded by, that I was very lucky to be surrounded by, and just great, wonderful people, wonderful classmates, and just a great place to be. Austin is awesome. I miss it sometimes. Let's see here. All right, we got Laura Ann from Minnesota. All right, all right. Sophie Glatt says hi from the UK, England, and Maya from Normandy, France. And let's see, Spetty Ross from Boston, Massachusetts. SG, morning from Killeen, Texas. Hey, I know Killeen. I know where that is. Sokotoa, hi from Cali. It's super windy on this voting day. Ooh, it must be a change of the winds, right? I don't know. Don't don't take that as any kind of a weird political message, please. I don't know. I'm just saying things. Amanda Lang, good morning. From BAME, Okanagan, British Columbia. Okay. I've never actually been to British Columbia, but I've heard that it's gorgeous. Okay, let's see here. 24 Celsius is comfy warm, not too hot. Okay, thank you. Is Celsius Greek to you? Basically. Pretty much, pretty much. Let's see. Oh, Brittany from Illinois. All right. And I think, let's see. We'll see if we can get a couple more here. Twisted Freak Show from Philly, Pennsylvania. Hello. Cheryl Schwartz from San Francisco. Sassy Amagurumi. Amagurumi saying hi from Ohio. All righty, folks. All right. And Andy the Game Maker, thanks so much for the first super chat of the day. You were in Austin only because I was at Fort Hood. That's not true. That's not true. It's the reason why I was in Austin is because in my year in between undergrad and law school, I had heard so many great things about the great state of Texas, and I was intrigued. I'm not going to lie. So I looked up law schools that were, well ranked, nationally recognized, to see if this is something that I, might be able to go back to California afterwards or elsewhere, or who knows, something more than a regional school. But anyway, so I found UT, really liked what I saw. It was like kind of the last random toss in, and was like, wouldn't that be interesting if I ended up going there? Like, because I literally just added that at the very end of my application process, just as another like random toss in. And yeah, ended up going there and I loved it. So yeah, but Andy, nice try trying to make it about yourself again. Big brothers. Come on, man. All right. Oh, Nicole Christine went to UT for nursing school and loved it. Right? Isn't it just such a great place? Nicole, here's a question for you. I hope that I can keep an eye out in the chat. If you want to answer, what is your favorite breakfast taco place in Austin? Because there are many good ones in Austin. Mine was this one little taco shop on West 6th. I don't know if it's still there, but it was taco truck, sorry, called One Taco. They had the best breakfast tacos that I've ever had. And it's like no one picks that taco truck as their favorite, but for whatever reason, mine, that was my favorite. I see Ophelia with the fair says Torchies. that is a common favorite. Uncivil law says One Taco's okay. Oh, okay. All right. Well, that's fine. So okay, all right. Let's get into I know now that we're talking about food, right? We're talking about breakfast tacos and all this great stuff. Let's get into the cases here before we dig into the details, because again, we're getting into testimony, we're getting into cross examinations, getting all this kind of stuff. And as you guys know, if you've been following both of these cases, there's definitely some testimony that's going to be triggering for some, right? So I know that especially since the Depp trial, a lot of viewers on this channel are folks that have been through DV, been through SA, been through, all of these kinds of traumatic experiences, and you guys feel very passionately about it. People have been have gone through various stages of healing from that. So I want to let you guys know that, the trigger warning, right? Because we're probably going to get into some stuff that may be triggering for you. I want to make sure that you have that, that you have that warning ahead of time. And by all means, like if you start to feel like it's too much, step away, right? Like do what you need to do to take care of yourself, to take care of your mind, to take care of your heart. And then, and if you feel like you can come back, later, then by all means, please come back, right? But don't feel like you have to be here, like you're stuck or anything like that, right? I First and foremost, I want to make sure that everyone that is watching is taking care of themselves, right? So just want to say that because there's already been a lot that we've talked about, especially in these particular cases, that has been very triggering for some. So yes, thank you, unnamed firestorm. That is the disclaimer right there. So yes. All right. Now I think that is everything that I wanted to say. And yeah, let's get into it, shall we? Let's start with Weinstein as we do in these cases. Okay, so we've got last Thursday, Friday, and now Monday to talk about in both of these cases. So we're gonna, a lot of these episodes where I've been talking about Weinstein and Masterson. Now with Weinstein, we've basically just been going through articles. Masterson, like I said, we've got Tony Ortega's wonderful commentary, and his stuff that we've been blessed to be able to use. So in Weinstein, I usually have been trying to find some diversity in a lot of these articles to try to make sure that we've got like different perspectives possibly. But I will say that some of that has been frustrating because, when I've wanted to have, for example, more detail on cross-examinations and all that kind of stuff, it's sometimes harder to find. So I found these articles from the Associated Press. They're all from the Associated Press today. And I think that's going to be sufficient. It's going to be fine. Keep in mind, things could be filtered out. That's always a possibility when we're working through these articles, because they probably have maximum characters or maximum word counts that they can use on these things. And there's always a possibility that somebody who is writing this article has a particular interest in drawing things up, in a particular way, right? So, of course, when we're talking about Weinstein, I have talked about this myself, that I've got a bias against Weinstein here, right? So even still, I try to point out things that are good and bad for Weinstein, because at the end of the day, we're trying to figure out how these trials are playing out, right? So regardless of whether we think someone is guilty or not guilty, we still want to make sure that justice is done, and that it's done properly, and that that somebody's due process rights are still protected, if for no other reason than to say that this guy doesn't get to have an opportunity for an appeal, right? Let's just let's say that we don't care about Weinstein here, right? We don't care about his due process rights in particular. I personally argue that it's not about the individual that is sitting here right now. It's about the individual that you care about that would be sitting in that seat later on down the line, that we are thinking about when we care about due process rights, right? Because we need to make sure that those are consistently held up case after case after case, because that's how we maintain legitimacy of our judicial system. So with that set aside, at the same time, even for a case like this, if you say, I don't really care, it's Harvey Weinstein, he can run in hell for all I care about, you don't want to give him an opportunity for an appeal, right? So it's much better when things are done properly, so you don't have a second Cosby situation. I know that a lot of people have and we've talked about on the channel too before, that there's a lot of anger over Cosby's release, and it's completely understandable, completely warranted. But it's not about the judicial system being unfair or being wrong. It was someone at the DA's office made a big mistake. And that's the consequence of someone at the DA's office making a big mistake. So we want to make sure that things are done properly for the defendant's rights, so that a mistake like that doesn't happen that ends up freeing them when they really should be in jail for a very long time. Hope that makes sense for everybody. Okay. So, all right. With all that said, okay, let's get into the actual article maybe, right? Okay. Woman says humiliation kept her silent on Weinstein assault. And I'm going to zoom in on this again so we can get these words as big as possible for everybody to be able to see. And yeah, Pamela C. Cosby got out because of a mistake. It was basic. Okay, let me explain this. So for folks that are not familiar with what happened there, he was convicted because he had testified in a civil case before he was put on trial with criminal charges. The problem is, in the criminal case, they used his testimony from the civil case, which is normally fine. The problem with that was his in the civil trial. The only reason why he testified was because he had gotten word from the DA's office saying, "We promise that we are not going to prosecute you criminally for these charges. So because we are giving you that promise, you don't have a Fifth Amendment right to not testify in the civil case." So if he had this possibility looming over him during that civil case that a criminal case might happen, he could say, Fifth Amendment, I have a right not to incriminate myself. You cannot compel me to testify. So he would have been able to say that. But because the prosecution, the DA's office said, look, like, we're not going to prosecute you, that eliminated that that reasonable fear, right, of him self-incriminating, right? Because no one's going to charge him. So how can you incriminate yourself if you're never going to be charged for something? The problem is that the DA's office then had a switcheroo. There was a new attorney that was filling in the spot of the individual that had made that promise. And they were like, I didn't make that promise. That was somebody else. I didn't make that promise. The problem was that it was still the person in that position. It doesn't matter who the individual is that's sitting in that seat. It's that seat that made that promise to Cosby. And so they ended up charging him after they had previously promised him that they wouldn't. And so the appellate court said, or actually, I think it even went all the way up to the state Supreme Court, if I remember correctly. I'm a little bit foggy on some of these details, but the important ones I'm not foggy on. The court ultimately said, yeah, that's reversible error, because you can't, the DA's office can't promise not to prosecute, saying that he then has to testify in a civil case and then go back on that promise. You just can't do that. Doesn't matter if it's Bill Cosby, doesn't matter if it's any other criminal defendant or potential criminal defendant, right? That is not something that our government can do, right? Because it's the local DA's office, but they represent the state, right? They represent the government, which has the full force, the full weight of the state with a capital S behind them. So those kind of rights are very, very, very important. And that's why Cosby got out. So it's not because of, people trying to undermine the Me Too movement. It's not because of any of those kinds of reasons. It is because somebody made a mistake by either by promising him that he wouldn't have to testify, or by going back on that promise. Somebody made a mistake along the way. And that's ultimately how he ended up getting out early. So yeah. Anyhow, long story on that. Now let's finally get back into Weinstein. But yeah. Okay. I know I keep promising that we're going to get into this article, and then I keep taking another left turn or a right turn to talk about something else. All right, let's get into it, shall we? Okay. A massage therapist testified Wednesday that the humiliation and embarrassment she felt at allowing herself to be repeatedly alone with Harvey Weinstein after he SA'd her kept her silent about it for years. The woman testified that in 2010, when she was 28, after briefly meeting Weinstein through a friend, she was hired to go to his hotel room in Beverly Hills to give him a massage. He cut the appointment short after about 40 minutes. And when she was in the bathroom washing her hands, Weinstein entered, blocked the door, and began doing things in front of her. I'm not going to say it because, like I said, I've said this before. I'll say this probably in every episode where we are talking about these kinds of cases, but I'm going to censor myself on some of these terms because YouTube does not like them, right? YouTube likes to punish certain words. So I am reading this article to you. You can read along with me, and I am gonna massage some of these words here and there so that I hopefully don't trip over the YouTube algorithm. And sometimes it works, sometimes it doesn't. Sometimes YouTube still uh, demonetizes these or limits the monetization, and whatever, it is what it is. These are important cases. Okay. I said, "What are you doing?" The woman remembered saying as she sat on the witness stand at the Los Angeles trial of the 70-year-old former movie magnate. "This is not appropriate. Can you please go back in the other room and get your clothes on?" She began to cry as she said, "I was terrified. I thought I was going to get AR'd." She said Weinstein was blocking the door, then pushed her against a wall and groped her before finishing. "I was in shock. I felt frozen. I felt paralyzed. I was trying to understand," she said. The woman who is going by Jane Doe in court was the second of 5 women Weinstein is charged with SAing to take the stand at his trial. I know. As soon as I said it, I was like, man, I probably shouldn't have used that word. But whoops. Oh, well. I mean, my attempts at self censorship don't always end up very well. But nice catch. um, anyway, yeah, I thought no one would notice, but you noticed. So good on you for paying attention. Okay. Anyway, the Associated Press does not typically name people who say they have been SA'd. The woman said Weinstein called and texted her repeatedly after the incident. A month or more later, she reluctantly agreed to see him again with the assurance there would be no sexual contact, excuse me. But Weinstein did open his robe and expose herself to him, or do they mean exposed himself to her during that massage? She testified. She later saw Weinstein again to work only on an injured foot. But when she was done, he began doing stuff in front of her again. She refused to take any money, she said, and cried as she said she was disgusted. Disgusted that just happened to me, and I just stood there. "That's one of the reasons why I didn't want to come forward," she said, "because this is embarrassing." She said she saw Weinstein one more time several months later when she introduced him to a friend who was publishing a coffee table book about Los Angeles. She thought she could avoid being alone with him, but Weinstein asked to speak to her alone. He again began doing stuff and moved toward her, grabbing her again. Yikes. "This time I screamed," she said. Asked why she didn't go to the police, she said, "I was humiliated. I was scared. I work on high-end clients that trust me," she said. "If I went public that I was SA'd by Harvey Weinstein and I didn't win, I wouldn't have been able to work with high-profile clients. That's all I work with." When she finally did go to police years later, she told them only about the first incident. She only divulged the others slowly in conversations with authorities and in testimony to the grand jury that indicted Weinstein. He is charged with 1 count of sexual battery against the woman and in total faces 11 R and SA counts in California. He is serving a 23-year sentence for a conviction in New York. Yeah, I see it in the chat. People are asking, why did she go back? Like, why did she continue to go back? I suspect that it probably has something to do with the fact that this is her work and her profession, and she says that she works with high-end clients that trust her, right? So, it probably is good money, I guess, to have someone like Weinstein who has a lot of power and has a lot of influence. Um, it may be good for business to keep him on the payroll, I guess, or I guess, or to have to stay on his payroll, I should say. Um, perhaps. I don't know, you know, sometimes it can be easy to judge someone in that kind of a position, right? Because we're thinking like money is money, but your dignity is everything, right? That's not always the case for people, right? Sometimes people have a much harder time choosing between those kinds of things, right? Because they've got very real expenses to pay for. They've got families to provide for. They've got, rent. They've got bills. They've got mortgages. Like there's a lot of there are a lot of factors involved in somebody deciding to continue working for someone, um, and providing services for someone. And when you have someone like Harvey Weinstein, it could be that she figured this is somebody who, if I hopefully it doesn't continue to happen. Maybe I can just sort of compartmentalize it, and I can end up getting more work from other people through him or something. I don't know. Maybe I'm just being a little bit of an apologist for this witness. And if you think that I'm doing that, call me out. Let me know. In the chat. If you're watching it on replay, let me know in the comments. Um, yeah, I don't know. Um, Maybe you see things a little bit differently, but I'm trying to sort of figure, like, by stepping in her shoes, um, seeing how things how she may have been thinking about things, from various different points of view. I don't know. Let's see. Let's continue reading here. Weinstein has pleaded not guilty and denied engaging in any non-consensual sex. The woman's willingness to see Weinstein again after the initial alleged assault is likely to be at the center of her cross-examination Thursday by his defense attorneys. She said the first person she told about the assault was actor Mel Gibson, one of her clients and a friend. He's expected to testify later in the trial. I have read that Mel Gibson is expected to testify, so we'll see if that happens. And if it does, I'll be very curious to see what his testimony is. Um, Ostensibly, he would be called to corroborate this witness's testimony, right? To say that she told him about it and what she told him about it, and exactly how it came up and all that kind of stuff. Because for all of these women, because these kinds of acts happen in private, in solitary kind of conditions, a lot of the credibility of these witnesses oftentimes comes from who they told about the encounter and when, and how they told them about it, and is their story consistent. um is their story consistent with what they are saying today in court. The issue came up involuntarily when she was giving Gibson a massage, and the actor director brought up a movie that he might be working with Weinstein on. I went into shock and I started crying, she said. He was the first person that I finally opened up with about what happened. I told him that he SA'd me, but I didn't want to get into the details. I was embarrassed and humiliated. And also, good question, Debbie Faison Cook. Isn't that hearsay? Well, so the definition of hearsay is an out of court statement that is offered to prove the truth of the matter asserted. So, you have to first determine whether or not it fits into that definition. And really what it comes down to, I mean, obviously what she said to Mel Gibson is an out of court statement, right? And it's being offered in court. So, you've got those elements of the definition, but why is it being offered is the biggest question. And that's usually the biggest question in any of these kinds of statements that are going to be introduced in court, right? Or that somebody's trying to introduce into court. And it seems like Mel Gibson wouldn't be saying what this witness told him to say that what she told him was what happened. It's not being offered to prove that actually happened to her. It's being offered to prove that she told someone about it, right? That she told someone about it earlier than probably earlier than 2017, right? When the Me Too movement sort of exploded on the scene, right? And Harvey Weinstein was like the chief banana that people were going after. So sorry for the for the double entendre. It was only as I was saying it that I realized what I was saying. I'm really doing well here today with some of these descriptors that I'm using. I'm sorry, guys. It's a Tuesday. We're doing well. We're rolling with it. Um, so, but yeah, so it's a little tricky because it's like if you look at it from the defense perspective, it definitely seems like it's being offered to bolster the idea that she actually was SA'd by Weinstein on a certain day. But um but from the prosecution's perspective, they are offering it to show that she was making consistent statements before. So yeah, I don't know. I don't know. um all right. So thanks, guys. Thanks. Seeing some support in the chat. Appreciate it, guys. Okay. Anyway, so that is the end of this article. So let's get into the next one, which talks about the cross-examination of this particular witness. But before we do, HWS, thanks so much for the super chat. It says, I'm so sorry I never get to catch streams. I do the best I can, but I live in Australia and I'm working 24/7. I love you all, though, especially Alita. Aw, thank you so much. Thank you. It's much appreciated. Never expected, but very much appreciated. And of course, that's why these streams get kept up. That's why these streams get kept up after the live stream, right? So the folks can catch it on a replay for when it's more convenient for them. But I really do appreciate you popping in, and thanks so much for the super chat. Always welcome. Okay. Here we go. Next article. Okay. Here we go. Yeah. Yeah. I am a little bit tongue-tied today, I think. You know what it is? I think it's because I actually had coffee today. I've been trying to get off of caffeine for the last like few weeks. No, actually more than like month and a half, I would say actually. I basically have been pretty much like dialing it back on caffeine because I realized I was starting to have like a pot of coffee a day, which is just like way too much. So but today I decided to have like 2 cups of coffee and I was bouncing off the walls a little bit earlier. So anyhow, but yeah. Hey, oh, hi, hi, hi. Oh no, I didn't feed you beforehand, did I? Oh, I'm so sorry. You're going to be bugging me this whole time. Sorry, pup. You're just going to have to be hungry for a little bit. I'll feed you in a bit. Don't worry. Don't worry. Okay. All right. On to the next article here. Weinstein attorney and an accuser clash over memory of assault. Now, okay. So this is where this is going to get interesting, right? And we've talked about memory issues. We've talked about how that is likely to come up in cases like this, in cases like Masterson, where we are talking about accusations over things that happened a long time ago, right? Masterson, we're talking about things that happened between 2001 2003. This, we're talking about things that happened around what, 2010, 2011, I think, 2013, 14. So still a very long time ago, right? And when we're talking about memories that are potentially traumatic, those tend to shift over time. Any kind of memories shift over time. I have a terrible memory, right? It's what makes arguing with Mr. Bites super frustrating because he has a much better memory than I do. And and sometimes you have those arguments where you're like, you know what? I really wish that I didn't have to, you're fighting unfair, basically. Anyway, no, I absolutely adore him and I love him and he is wonderful. Okay. But yeah, memory is potentially an issue here, right? So this is something that we've talked about before and it's going to come up in this cross-examination. Okay. An attorney for Harvey Weinstein suggested Thursday that the shifts in a massage therapist's account of a 2010 SA by the former movie mogul meant she had fabricated details, while she insisted that working through the trauma had drawn out more accurate memories. So, and this is also something that the expert witness in this case testified to as well, right? This was, I think, last week we heard from the expert witness that was an expert on this kind of trauma said that traumatic memories tend to be they tend to shift over time, but it's usually going to be the details around the edges. The most important things are going to be remembered. The problem for the jury with that, though, is trying to parse out which ones are most important, which ones are worth sort of focusing in on, right? Like that's the real challenge in cases like this. So that's where having these corroborating witnesses where someone has told um where someone has told someone else about what happened, and they did so before there was a an allegation or a possibility that they could have fabricated or corroborated for some sort of a reason, right? Some sort of a motivated reason, either because they encountered other people that went through the same thing or allegedly the same thing, or whether it was because there was a new social movement that people were sort of charging ahead with full force without really trying to perform some kind of a validation process, right? To sort of try to understand where people were just kind of like accepting people at their word and just running forward. Amber Heard, we're all looking at you. So yeah, that's what corroboration like that is so important. Okay. Okay. All right, all right. Let's continue on. Okay, Weinstein attorney Mark Worksman pointed out differences over time in stories she told to police and prosecutors in 2019 and 2020 in her testimony to a grand jury last year and in her words on the witness stand Wednesday when she said Weinstein had trapped her in a bathroom, done stuff in front of her, and groped her after hiring her for a massage in a Beverly Hills hotel room. Do you think your memory is better now than it was 3 years ago? Worksman asked. Yes, she answered. At another point, she said, my memory was foggy then, but I remember everything now. The woman said discussions about the assault with friends, authorities, a therapist, and others had brought clarity and made her face difficult details that she had buried in her memory. Um, this is difficult, right? I wonder if the prosecution plans to bring her therapist to the stand to testify, because now normally conversations between a doctor and a patient are privileged, right? They are privileged because there's the law wants to encourage people to talk to their doctors even about the things that are uncomfortable and difficult and all that kind of stuff, because the law wants to encourage people to get treatment, right? That's the policy reason behind it. Um, but she can always consent to have her therapist talk, right? The client, or the patient, I should say, has the ability to waive that privilege if she so chooses. So I don't know. I don't know, but I'm not saying that it's necessary, but it would be interesting to see, as someone who's kind of objective on this. Um, okay. So, but this is interesting, right? Because this is the opposite of what people would expect. We've got her saying that her memory is better now than it was then. To me personally, I have to admit it does ring some alarm bells a little bit here, because we're talking about the possibility that her mind, her memory could be influenced by framing that other people have given her over the years, talking with friends, authorities, a therapist, and others. That is a possibility. That is definitely a possibility. Um, but it could be that she, you know, tried to compartmentalize things. That's a possibility, I suppose. Um, but yeah, with this witness, and like I said, I am biased against Weinstein, right? Like it brings me no joy to say this, but I doubt this a little bit. Okay. Worksman asked if the conversations represented an effort to build consensus. The woman insisted it wasn't. The more I spoke about it, the more I recalled the trauma that happened to me, she said. I was blocking it out for so long. And that's a possibility. That's definitely a possibility. Again, we can't see her testifying right now. So, the jury obviously is there in person. They're able to see her body language, see if she comes across as sincere or not. Um, that's obviously a judgment call. I mean, it literally is a judgment call for the jury. So, for us, we've got words on a page. It's entirely different than actually seeing someone um actually testify in person. So, I mean, I will say this is a possibility, but I do have some sense of skepticism right now on this. Okay. The woman is going by Jane Doe in court. The Associated Press does not typically name people who say they have been SA'd, which is good. Weinstein is charged with sexual battery by restraint for the incident. One of 11 sexual or SA counts. Sorry, guys. One of 11 SA counts involving 5 women he's charged with at his Los Angeles trial. He has pleaded not guilty and denied engaging in any non-consensual sex. He's already serving a 23-year sentence for a conviction in New York. Worksman especially dwelt on whether Weinstein touched her over or under her clothes, suggesting her story suspiciously shifted over time to include the skin-on-skin contact required by California law for sexual battery. You didn't change your story from "it didn't happen at all" to "I'm 95% sure" to "I'm 100% sure," so that they could criminally prosecute Mr. Weinstein? Worksman said. No, she said. Your story is like the US economy, 8% inflation, isn't it? Worksman said, though the judge rejected the question after an objection. Yeah, that's definitely an objectionable question for sure. That is argumentative. And yeah, that's just kind of a rude comment, kind of a snide comment, and it has no place in a cross-examination. She testified Wednesday that she had been embarrassed and humiliated, that she had allowed herself to be alone with Weinstein several times more, including 2 more massages where she said he engaged in similar unwanted sexual behavior. The defense seized on the issue during cross-examination, which, and before we get any further, I mean, this was another thing that the trauma expert testified to, right? Because the expert testified about the fact that sometimes people will go back to someone because they feel like they're damaged goods, and they feel like, that's I may as well go back because who would want me now, right? That kind of thing. Um But she also might have a financial incentive, a business incentive. She might feel like she kind of has to. I don't know. I mean, it's interesting. And again, this is probably a detail that came up in cross-examination that we just don't get from this kind of not from this kind of journalism, but from, generally speaking, journalism in general. He calls for another massage and you say, "Buzz off, creep," and hang up, right? Worksman asked. No, the woman said. No, Worksman replied. You schedule another massage. During the first massage, Weinstein and the woman discussed her writing a book about her techniques for the publishing arm of his movie company, Miramax. Worksman suggested that the woman had done a consensual sexual favor for Weinstein to better her chances of being published. And so this, I think, is probably one of Weinstein's biggest theories here for what the defense is trying to put forward, is to say, look, Weinstein is somebody of a lot of stature. He's someone of a lot of power. And so there are women out there that want to take advantage of that for their own purposes, to better their careers by sleeping with a man, sleeping up, essentially, right? That's the concept. That's the idea. That you sleep your way up to success, right? And then on top of that, then the Me Too movement happens, and then the woman turn around and sort of like sleep up again by claiming that it wasn't consensual. That's what the argument is here. I don't know. I mean, the testimony that we've heard so far, again, coming through a filter of a journalist in on paper is can be difficult to parse through sometimes. Um, but personally, for me, it seems like the testimony here has generally been pretty reasonable, I think. And even the articles that we've gone through where they've talked about cross-examination, it doesn't seem like anything major has really stuck, where we're talking about the timeline of these women, and the people that they talked to, the people that they told their stories to before 2017. That helps to bolster their case. Okay. You pursued a book deal because that was your end of a bargain for having sexual relations with Mr. Weinstein, correct? He asked. Incorrect, she said. The woman said the book had been Weinstein's idea, and while she was intrigued and took part in several months of emails with his employees, the decision to drop it was mutual. So, that is something that is potentially some reasonable doubt that they're at least trying to interject, right? Oh wait, that is not the right one. I need this one. This one. Okay. They're trying to interject some reasonable doubt here to see, if they can try to knock down one or two or maybe all of these alleged victims. This is probably the weakest one that we've seen so far. I don't know how the jury's going to come across with it because of the fact that, again, we can't see the testimony here. So we don't know what the jury's thinking, what the jury sees, if they're even paying attention at various points in time. That's pretty important information to figure what information they're even considering, right? So anyway, but let's continue on and see how the next day went. Okay. Weinstein accuser takes a stand in LA after New York testimony. So we've got a witness who is a crossover from the New York trial. The New York trial of Harvey Weinstein and its California sequel had a rare crossover Monday as the only accuser of the former movie magnate to testify at both took the stand in Los Angeles and said she was SA'd by him in a Beverly Hills hotel bathroom in 2013 while repeatedly telling him no. Lauren Young said she was paralyzed by fear when Harvey Weinstein blocked her from leaving the bathroom, did stuff in front of her, and groped her front. So, I mean, this is, I can't remember if this is one of the actual, one of the alleged victims that is related to one of the charges or not, because there have been some alleged victims that have testified so far that aren't related to any of the charges, but they are there to basically help to establish an MO, so to speak, modus operandi of like what he typically did. And this appears to be a pattern, right? There's a hotel. It's either his room or it's her room. He somehow ends up in the room with her. Suddenly he's like snaps and he's clothesless, right? He's totally nude and he's doing stuff to himself and grabbing her, right? Like this is like what has happened in just about every single one of these instances, it seems like. Except for some of them have been even more graphic and even more intense. But so far, I mean, this definitely fits the pattern that we have seen so far with a lot of these witnesses and what they've testified about their experiences. I was scared of Harvey Weinstein, that he would hurt me or send someone to hurt me or ruin my career or make my life hell, Young told the court. When Young testified in New York in February of 2020, she was not one of the accusers whose stories would lead to Weinstein's conviction for R and SA and a 23-year prison sentence. But prosecutors called on her to testify to help establish a pattern of Weinstein preying on women. She definitely fits the pattern, right? In Los Angeles, Weinstein is charged with sexual battery by restraint for the same allegations. Young said Monday that in early 2013, she was a model who was aspiring to be an actress and screenwriter. And through Weinstein's assistant, who had become a friend, she set up a meeting with him at the Montage Hotel on the night of February 19th, 2013, about a script she was working on. During the meeting, Weinstein said she should accompany him to his room to continue the talk while he got ready for an event. Oh, God. We can see where this is going. Young said Weinstein led her into the room and then the bathroom, and his assistant shut the door behind them and left him alone. This assistant has done this multiple times, apparently. So this assistant definitely has some Ghislaine Maxwell vibes, right? Because she definitely has assisted Weinstein in many, many ways, it seems, which is just awful, awful, awful. And I feel like she should be charged as well. She said she was stunned as he quickly shed his suit and got briefly in the shower, then stepped out and blocked her from leaving when she went for the door. I think the assistant is a woman, right? I think so. Wait, let me hang on just a second. I've always had this impression that the assistant was a woman. Let me see if maybe somebody else can. Maybe someone else will find it before me because this page is not loading. I'm going to keep reading. Interesting. Okay, hang on. We're going to do a little bit of sidetrack research. Okay. Well, okay, hang on. Hang on. Harvey, oh, dang it. Come on. Harvey Weinstein assistant. Let me see here. A woman. Yeah. This is there's a Deadline article from a few days ago. Harvey Weinstein's former assistant testifies she has no recollection of meeting accuser in Puerto Rico. Let's see. One of Harvey Weinstein's former personal assistants, who was mentioned prominently in accuser Ashley M's testimony, took the witness stand today in the disgraced former mogul's SA trial in Los Angeles, saying she has no recollection of meeting Ashley M in Puerto Rico. So he probably, okay, that's fair. Nolita 505. He may have had multiple assistants. That's entirely possible. Okay, yeah, because there's another one stuck on string says, according to Variety, her name is Rowena Chu. So I think that there might be multiple. Yeah, Bonnie Hung is another one. Bonnie Hung, who met Weinstein in 2001 and became his personal assistant 2 years later, was asked by prosecution lawyer Marlene Martinez about Ashley M's alleged 2003 hotel encounter with Weinstein during the production of Dirty Dancing. Okay, so yeah, Bonnie Hung, Rowena Chu. There may have been others as well. Yeah, interesting. Very interesting. And I wonder if they have any allegations against him themselves. Kind of like, I think Ghislaine Maxwell also was apparently at least an alleged sex trafficking victim herself. This is what I've read. I think House and Habit has talked about that quite a bit. I think it's maybe not exactly the most popular opinion, But I know that it is out there. And that also often tends to be the case in these kinds of cases where somebody starts to assist someone in that. Oftentimes it is because they themselves are trapped in some respect. Okay. All right, let's come back to this particular article after that little divergence. Okay. All right. She said, okay, so I was disgusted. She said, I had never seen a big guy like that naked. She said she backed up against a sink and turned away from him. He then unzipped her dress and groped her with one hand as he did something with the other. Weinstein's attorney, Alan Jackson, gave the 2-week-old trial rare moments of visual drama with a pair of clothing demonstrations during cross-examination. He pulled out the dress Young had been wearing that night and got her to acknowledge that a DNA test failed to prove Weinstein had touched it. Which, I mean, that is sure. Defense absolutely should point that out if that is the case, but I have questions about that, right? Was this a Monica Lewinsky kind of dress where she saved it as a as an item, that still had not been washed? Or was this something that she immediately took to the dry cleaner to try to get rid of that stuff? I don't know. We don't know that based on how this is written, right? All we know is that there apparently wasn't any of his DNA on it. That also doesn't mean that it didn't happen, right? he uh this totally could have happened. That dress could have been involved in that incident, and uh eh, it could be that there's no DNA or insufficient DNA to have um a reliable result come from that. And so Katoa has a random question: is touch DNA reliable? Well, the thing about touch DNA is it's based off of like your skin cells coming off, right? Which is very different than, say, bodily fluids, right? Which have a, generally speaking, I think, now, okay, don't take this with a grain of salt, right? Because I am not um I'm not like a forensic biologist here, right? So I'm not a scientist. I haven't worked with touch DNA myself, but my impression has always been that touch DNA is there's just less DNA to possibly get a result, right? And so you are more likely to have, well, a false negative than a false positive, right? If that makes any sense. Oh, and Sandra, thanks for the super chat, says if it was only touch DNA they were looking for, it isn't always reliable. Okay. So um yeah, there's just less of it, right? Because we don't walk around leaving a trail of skin cells everywhere, at least not in huge amounts, right? Unless you have particularly dry skin and it tends to get everywhere. That's not always necessarily the case, especially if you think about it. If this happened right after he got out of the shower, if he has just scrubbed himself down, that probably has gotten rid of whatever loose skin cells he had on his body more likely than before the shower. So, yeah. So, Sandra, thanks for the super chat. And yeah, Brandon has me. You have to get a lot to get a match. Yeah, they often have insufficient samples. That makes sense. That makes a lot of sense. And Sandra says that she's a genetic genealogist, and it's the easiest to be compromised. Okay, there you go. There you go. Okay. All right. Jackson also tried to cast doubt on whether Weinstein could have slipped out of his suit as quickly as she described. He pulled off his own suit coat to demonstrate. I don't I can see his point in what he's trying to do there, because you want to give the jury an idea of how long these things kind of take. But as a defense attorney, putting yourself in the in the shoes of the potential assailant, I don't know. I don't know. That's a potentially risky move. I mean, especially because their response is, please don't, Young answered. Because he said, I'm just going to take my jacket off. I'm not going to go any further. Jackson said, please don't, Young answered. Um, sh- that's a good response. That's a good response from that kind of a witness to say, like, nope, I'm uncomfortable with this. I'm very uncomfortable with all of this. Um, when asked how Weinstein could have unfastened everything so quickly, Young answered that he may have gotten started while he was walking down the hall, a method she used to use for quick changes as a model. Does Mr. Weinstein strike you as a model? Jackson asked. No, but he's definitely a monster, Young replied. Okay, so I get it. The defense attorney needs to do whatever they can to try to poke holes, to say, like, okay, do you really think that he's a model? He also is really big in the entertainment industry, right? He's constantly around actors and models, actors that are on stage, actors that are in film. And um so, there are plenty of opportunities for him to learn those techniques even without him being a model himself. And especially if he is doing this in a very serial kind of way, right? Like all of the women that are coming out of the woodwork, they all seem to be saying very similar things, right? This is kind of what he tends to do. If this is something that he has a habit of doing, when you are in the habit of doing something, you tend to get really good at it over time, right? Practice. Oh God, practice makes perfect, right? Like I feel gross saying that, right? But it could be one of those things that he just picked up strategies over time and started to really figure out how to get very efficient about it. As gross as the whole subject is, and as gross as it is to think about it, that is definitely a possibility here. Like all women, Weinstein is charged. Like all of the women, Weinstein is charged with SAing at the trial. Young is going by Jane Doe in court. The Associated Press typically does not publish the names of people alleging SA unless they give their consent, as Young has done through her lawyer. Okay. Young's testimony closely hewed to her account during the New York trial, but during cross-examination, Jackson pointed out that it differed in many respects from her early accounts to police starting in 2018 when she called a hotline set up for reports about Weinstein after the Me Too movement exploded. Young initially told detectives that the assault had taken place a year earlier, days after she had been at a dinner with Weinstein at a Beverly Hills restaurant. Jackson pointed out that she was saying the same as recently as 2020. So that's a potential problem in her testimony. I'm not going to lie. To get the year wrong, right? The date, I can see getting that wrong because dates can be fluid. All kinds of things can happen to inform one date versus another. Your memory can definitely get tripped up on that fairly easily. Years are a little bit harder to miss, right? Um, so is that going to matter? I don't know. I don't know. It's up to how the jury interprets that difference, right? I was sure that I was sexually assaulted, Young asked. That wasn't my question, the lawyer replied. I'm asking about the time, something that would stick in your mind. Jackson also brought up her previous confusion about the site of the assault, and she acknowledged that she could not name the hotel in her first three interviews with authorities, the most recent in 2020. Okay. I mean, hotel name. Some chains can get mixed up between one another. That is something that I'm much more willing to give some flexibility on. But the year, I don't think that's a good sign for this witness. I had pushed it out of my memory, Young said, which is entirely possible. She decided it was the montage when police suggested it and took her to the suite where Weinstein had been staying. And since then, your testimony and your statements have gotten so, Sorry about that. That's Indy running around and playing with Holmes. And since then, your testimony and your statements have gotten far more detailed and far more colorful, right? Jackson said. My trauma, I got to relive it by walking through that room, Young said. I had been in other rooms and didn't feel anything. When I walked in that room, I felt everything flow back in. I can see that. I can see that. Sometimes going to a particular place has a tendency to trigger memories that you otherwise would have forgotten, right? I mean, how many of us have done that thing where you you're at home and you go downstairs to go and get something, right? And then as soon as you're at the bottom of the stairs, you're like, what was I going to get? What was I supposed to do just now? Was I supposed to pick something up, put something down, write something down? Like, what was I going to do? So then you go, and then you go back upstairs. And as soon as you're back upstairs, you're like, I remember now, right? Sometimes location has the ability to trigger these memories. So this explanation, I will accept, right? Because that to me makes sense. According to allegations in an indictment and court testimony, the assault of Young came the day after Weinstein AR'd an Italian model at a different hotel during the run up to that year's Academy Awards, where Weinstein was annually a major player. The day after. Ugh. So these are one day after another. Weinstein, 70, has pleaded not guilty to 11 counts of R and SA involving 5 women. He has said that many of those incidents were consensual, though in the case of Young, his defense denies there was any sexual interaction at all. Okay, interesting. Okay, so that is the end of this one. Yes. No, it's not the end of the live stream, Indy. I'm sorry. I know you're hungry. I'll feed you soon, okay? Okay. So let's get to the next case here. But before we do, let me get here. I think there was there were a couple super chats here that I needed to get to. Shibaka Wookie, thanks so much for your super chat. It says, will you touch the Jared Lessig court case after his court appearance this month is absolutely horrific. Bye-bye adventures with Purpose's legacy. I don't know anything about this case. Oh my gosh. Excuse me. What are you doing, pup? What are you doing? I know you're hungry. Hang on a sec. Let me write this down if Indy will let me. Okay. Okay. Now, thank you so much for the super chat. I will definitely look into this one and add it. Okay. HWS says, I've lost my little brother recently. Cannot remember a thing about him in hospital or anything until I start talking about it. I believe her. Okay. Well, first, thank you for the super chat, of course. Also, I'm so sorry for your loss. And I trust you on what you say as to your personal experiences. So it definitely is possible that trauma that heavy can create a certain vacancy. So that's definitely a possibility with that particular witness. So because as I have said, and I'll say this again too, that the reason why traumatic memories tend to be so foggy is because it's the brain's way of trying to protect itself, right? Our bodies are constantly trying to protect ourselves from harm in so many different ways, and the brain is no exception, right? The brain is trying to protect us from harm, from mental anguish, and that is one of those ways that it does it is just by trying to kind of just forget, right? By trying to forget the memory. But it makes sense that sometimes the memories can be sort of triggered. They can be pulled out. They can be drawn out through conversation, through going into a familiar location, right? That triggers a particular memory. Sometimes it's smell, sometimes it's taste. There are different ways that a memory can be triggered through various experiences. So yeah, thank you so much for your insight. And that's a very, very good point. And again, I'm so sorry for your loss, and I hope I hope that you can get to a place where you can have those memories, you can relive those memories, and you can have some peace with those memories as well. If you can't at this point right now. Let's see here. And we've got another super chat from Shibaka Wookie. Feed the pup. We can wait 3 minutes. She can wait. She can wait. It's fine. It's fine. Discipline will do her well. Yeah. Well, let's get on to the next one. Okay. So now we've got Masterson. And like I said before, I'll say it again. Tony Ortega is doing a fantastic job of reporting on this particular case by going into the courthouse every single day, writing up on it. He's got his Substack where he gets basically typing up transcripts, which is amazing, right? You can't get that anywhere else. Hi. You can't get that anywhere else, right? Because no one is doing that. He's got other journalists that are in the room, and no disrespect to any of those other journalists, but he's really doing the best job here because we're able to see exactly what he's saying. So linked or pinned in the chat right now, and also in the description below, there's a link to his Substack where you can go and read all of those transcripts. So if you are interested in this case, you want more details, please go over there, check him out, sign up for his Substack. Indy agrees. Hi. I know. You know what though? You'll survive a little bit longer. Don't worry. We feed you really well. Even though you try to make it look to the world like you're starving, you're not. I know you're not. You also steal food from the street. Okay. All right. Let's get into. Oh my God. Are you serious? Okay, guys. All right. You know what? Give me a second. All right. Folks in the chat are saying that you can wait. Okay. Give me like 3 minutes. I'm going to feed her really, really quick. Okay. All right. Don't go anywhere because it's going to be interesting. It's going to be really interesting. Okay. All right. And we're back. Hang on. Let me just make sure that my audio is correct here. No, it's not. I'm glad I checked. Okay. All right. Cool. All righty. Okay. I appreciate everyone talking amongst yourselves, probably playing the Jeopardy music. Probably. Oh, there you go. Yeah, Aaron H was was doing the Jeopardy music. That's awesome. Okay. Now we should be good. Unless Indy, of course, decides to tell me that she has to go to the bathroom. Alrighty. Let's get into it. Let's get back into it. Okay. So we've got days 14, 15, and 16 to go over for the Masterson case here. And it's going to be interesting, right? So on Monday, the most recent yesterday, hello, there actually wasn't any testimony. It was all arguments and motion practice in front of the judge. So that's interesting. But before that, we do have some interesting testimony to get through. So let's go ahead and get into it. And we'll start with Tony Ortega doing his great, wonderful job. And then I'll pause it with commentary as we go along. Okay.
Underground bunker.
Hope you guys can hear that. Okay.
Proprietor.
I think I'm going to boost the sound.
On Thursday afternoon, November 3rd, I'm obviously not outside the courthouse.
I think that's better.
We came out of court this afternoon, and there was a freaking hurricane blowing outside the Clara Shortridge Foltz Criminal Justice Center. I couldn't record this there, so I've relocated to a tavern in Los Feliz, working on an IPA. Gonna give you the news. All right.
I might actually know what tavern he's at.
We finally got Detective
I'm familiar with Los Feliz.
On the witness stand today. And I know there's been a lot of buildup about her. The victims have talked about that they felt the investigation under her was really being mishandled. But keep in mind, this was the DA calling her to the stand. You're not going to have the DA trash a cop, right? I wasn't sure what to expect. And actually, what happened with Mueller questioning her was just like with Officer Schlegel and Detective Myers, he just went with her over all three cases, Jane Doe 1, 2, and 3, about all the things that corroborated what they're saying on the stand. That in 2017, when she was interviewing them, he went through each case that she told you about the jacuzzi and the drink and how the rape went. Yes. So just all corroboration until finally. Oh, and then the other thing was, like with Schlegel, she had to constantly check her reports, and we'll come back to that because it became an issue later. But she had to, but she would check her reports and say, yes, she told me about Jane Doe 1 being thrown in the jacuzzi, Jane Doe 3 about waking up in pain, Jane Doe 2.
Are you guys okay? So I see in the chat you guys are he's a bit quieter. Let me see if I can turn this up a bit more. Again, slow but audible. Okay, hang on. Let's see if this is better. Okay. Why does this keep happening like this? Okay. Well, all right.
Being asked to drink.
Is this better? I hope.
Red wine. Just all.
Hang on. Let me. I'm going to pause it so that you guys can respond here. Or do I need to turn it up more? Same. Ugh. Okay. Come on, Sound Booster. Work for me. Still quiet. Okay. Let's try this now.
Down the line, everything was.
Oh, I think this is better. For me, it definitely seems better.
Corroborating, basically.
Okay, so is that? Let me know in the chat if that's any better. Yeah, uncivil law. Why can't StreamYard get their shit together? I don't know, man. Yeah, only his levels are low. Okay, it's still the same. Oh my gosh, this is like wild. Okay, let me see if I can also boost it through here. My mic is loud. Sorry. Okay, I will put on CC. Okay, and let me see if I can. I'll put it over here in the corner so that it's not blocking his face. Okay, and I'm gonna come back a little bit too because let's see. Okay, let me know if this is any better. Actually, I'm going to turn the sound booster all the way up. This is literally 600%.
Yes, she told me about.
Whoa, that is really loud for me. Hang on. It's like impacting the sound quality. Okay, let's try this again.
Jane Doe 1 being thrown in the jacuzzi. Jane Doe 3 about waking up in pain. Jane Doe 2.
Better. Okay, good. Okay. All right, good. Thanks, guys. Okay. And I'm going to go back just a little bit more because I know that we were kind of focusing on the sound issues and stuff. So, okay. All right. Okay. Sound boosters for the win, man.
Until finally, and then the other thing was, like with Schlegel, she had to constantly check her reports, and we'll come back to that because it became an issue later. But she had to, but she would check her reports and say, yes, she told me about, Jane Doe 1 being thrown in the jacuzzi. Jane Doe 3 about waking up in pain. Jane Doe 2, being asked to drink a big glass of red wine. Just all down the line, everything was corroborating basically. And then we got corroboration of something I've been telling you about for 5 years. And that was the LAPD asked these women to make pretext phone calls. What that means is they were told to try to call Masterson or some of the other witnesses in the case and secretly tape them in order to get them to talk about what happened. And again, this was the LAPD asking these women to do this. And first of all, that kind of goes against, Cohen keeps asking, didn't you tell them not to talk to witnesses? Didn't you tell them not to talk to witnesses? And Mueller was saying, yeah, but you were asking them to call witnesses, right? And record them. So that was fun. But here's the thing.
Yeah, I have to say I don't quite know what exactly to do with that, because I also know that California is a two-party consent state when it comes to communications being recorded. I've actually used this in litigation before. I've talked about it before, with regard to other cases, that in order to admit a certain piece of audio evidence in court, both sides have to have consented to that recording. It can't just be a hidden recording that gets sprung up on the person who's been recorded unwittingly, right? You can't just spring that on them in litigation, because that's something that not only would it be kept out, but that the other side can then turn and add to their claims against the other person. So, but I don't know. I mean, I've used this in a civil context, and I don't know. I haven't done research to see if there's anything and any change with how that's used in a criminal context. Okay.
That's important is that she described the process, and that the technical division at the department had to set up these phone lines, these phone numbers that these women could use so that they would be using their own devices, but to the person they were calling, it would appear to be this sort of random phone number they wouldn't recognize, so they wouldn't be tipped off.
I don't know what the point of that is, though, because at the same time, if they're trying to elicit this information, doesn't the other side know who they're talking to if they're talking to that individual? I don't quite understand the reasoning behind using these fake numbers. Maybe someone else is who in the chat who is also familiar with this case. You have more information than I do, but so far I've heard this. I've heard about this issue before. Tony has talked about this in other videos as well. But I still don't quite understand what that whole issue is. I mean, other than he's going to get to another important detail in a second. So maybe I'll continue and then I'll maybe give more thoughts.
But then Deputy DA Mueller said, yeah, but didn't you give them a phone number that turned out being compromised? And
that's the issue.
Detective Reyes, who's now Detective Mayape, by the way, she's got a new married name. She said that, yeah, one of the numbers happened to be a phone that had already been burned in a sting operation. How did you find out about that? Jane Doe 1 figured it out. See, this is something I've been trying to convey for 5 years now. What these women have been up against and how often they've had to rely on their own initiative, their own work to keep this thing on track. The LAPD gave them a phone number that was compromised. All you had to do was enter it in Google and bam, it came up. Cop phone, don't talk to them.
Yikes. That yeah, this is another case where the LAPD, LA Sheriff's Department doesn't come out smelling like roses, right? We've talked about other cases. Now, I mean, the other big one that we talked about was Vanessa Bryant's case against the LA Sheriff's Department related to the photos of Kobe Bryant at the crash site. So that one was, I mean, that was all things that the LA County Sheriff's Department didn't do well, right? So there's a lot of shade in that case being thrown at the Sheriff's Department for very good reason. But I don't know, man. Like this is another case where it's like, yeah, these things are happening and they're not good. If it's something that you can easily just Google the number and that's how they figured it out, it means anybody else can Google the number and figure out that there's something fishy happening with this phone number, with this phone call. And again, I'm wondering what the strategy was with using these sort of burner phone numbers in the first place, right? If the individuals on the other end knew who they were talking to, wouldn't they have just expected to be talking to them on their phone number by themselves? Or I don't know. I don't really see the point if they knew who they were talking to. I don't know. I mean, now if they have a different phone number and that phone number is known to be a compromised number because you can just Google it, that definitely triggers suspicion on the other end of like, what are you doing and why are you doing this? You know? So I don't know. I still don't get the strategy. Maybe somebody else knows it better than I do. But that's a good idea. Twisted Freak Show. I could ask Detective Seeds. Yeah, he probably would have some insight on that. Okay, well, let's continue on with this.
And who figured that out? Jane Doe 1, not the LAPD. Sorry, I get a little excited about this because I know what these women have been through. And that was great to see this LAPD detective confirm that. She had no excuse for it. She said it was just a bizarre mistake, whatever. But, it's confirmation that these women were really concerned about how the LAPD was handling things. So then it was time for cross-examination. And this is when the reports thing came up because Cohen was saying, hey, if you
Oh, and I will say also, one thing that is very clear here is Tony definitely comes across as somebody who, in a sense, is advocating for these women, right? So he doesn't come across as somebody who's like completely neutral in this, although his commentary on the trial has been pretty good, where he has talked about the defense. Sometimes he's given them some compliments and stuff too. So I want to point that out because I think that there is a bit of a slant coming from him, but I do think that he is being honest with his observations in here. And I think that the reason why I still feel like I can trust what he says is partly because of the fact that he is doing those daily transcripts basically multiple times a day, pushing those out to people as soon as possible, where he's basically just transcribing what's going on in the courtroom. Because you can then go back and look at the transcripts that he provides and compare them to what he's saying in these videos and line them up and say like, okay, I can understand where he's got his opinions coming from. Right. So, I wanted to say that as well.
The DA usually, I'm sure you've testified hundreds of times. The DA has you come into court. Don't they usually give you these reports ahead of time so that they're fresh in your mind before you testify? And she said most of the time. I thought that was very good. She wasn't giving Cohen everything most of the time. But you weren't given the reports ahead of time this time, were you? No. So Cohen tried to make an issue out of that. But again, this was one of those things where I felt like it kind of felt like inside baseball in the legal community, and I wasn't sure how much that was going to translate to the jury. I may be wrong, but it just felt, I don't know, like a minor point.
I mean, it could, and I'm sorry, I keep pausing these on his face here in in frames that are not the, oh no, that's not, I'm sorry. Okay. Well, let me make it smaller at least. I'm sorry, Tony. I don't mean to pause it uh in anything other than a flattering position. I can totally understand what he's saying here, right? Because he's basically saying the defense is trying to score points at every possible place, right? The prosecution's trying to score points as well. Sometimes these lawyers that are trying a case, sometimes the lawyers that are trying a case can get so caught up in the weeds that things that they are like feeling really good about that they nailed some points on a particular witness might not translate to the jury, right? Because if there's this protracted argument about whether or not Detective Reyes was able to see her report ahead of time, or whether she remembers things from her report, jury might not care about that, right? They might not care because they might think this is a report that she wrote how many years ago. And if she hasn't looked at it in a while, she's not going to remember it. So what's the big deal, right? On the other hand, they might say, okay, like what kind of things, like what does she actually remember from this? Like, what is the point in really talking to her? We might as well just look at the report because that seems like that's probably more accurate. And she might not be fully accurate about what she's saying and what she remembers. Maybe she's, expanding things in her memory outside of that report now as well. So yeah. But and I do see in the chat, Shibaka Wookie, Tony isn't involved in the case. He can be as biased as he wants. I love that he stands for the victims and how ridiculous the defense can be. Fair. Absolutely fair. He has every right to have the stance that he has, right? And to be fair to him, he also has been covering this case for years, right? I think he helped to break the story in 2017. So it's like he's been following it, he's been writing about it along with tons of other stories about Scientology for decades, right? That he's been writing about Scientology and other stuff, of course, as well. So he absolutely has every right to have an opinion on this particular case. The only reason why I talk about it is because I have an understanding that can influence like the my opinion and the way that I have an outlook on a particular case can also be influenced by the type of information that I'm taking in, right? So that's why like I try to see if I can get information that is impartial, usually, like wherever I can. But where the information that I'm getting is potentially partial to one side or the other, I at least want to be able to identify that and then also be able to identify whether or not that partiality is going to impact the kind of information that they present, right? I don't have any sense that he's ever duplicitous, because he's like running too quickly with advocacy, right? 'Cause that's a possibility where somebody feels very passionately about a case, right? Um, but that's a possibility in some cases, and I don't get that sense here from him, right? I do feel like he is being very, very honest about how he feels about this, and I think that he's being very honest about what he has observed in the courtroom as well. So that's the only reason why I mentioned that kind of stuff. But I do appreciate your comment, Shibaka Wookie, about that. And I know that you are not alone in this one. So, okay. Let's continue on.
he wasn't able to cross-examine her much. I mean, he did go through the things that these women told her that are different than in their stories. No gun, for example, or she had, God, I don't want to get this wrong. Jane Doe 1 had told Reyes about the gun, but there were other things that he went over. You can go through my notes about things that she said yes to as far as things that were different. But the cross-examination ended early because she had to leave.
So it sounds like at least from Tony's impression, is that there were some differences, some distinctions that came up in cross-examination, but they may have been distinctions without a difference, right? I love using that phrase because you can nitpick, you can find, differences between one account and another account, but do those differences really matter is the big question, right? And so it sounds like from his assessment, and of course, we're kind of taking like the bird's eye view on these, right? Because we're not digging through these transcripts, which, if you are interested, please do dig through these transcripts. Link is in the pinned comment, and it's in the description below, so that you can dig through to see where those inconsistencies come out. But I mean, the cross examination may bring those up, but the jury might not care, right? Because if the main details are corroborated and they are, they come across sincerely with these various witnesses, then the things that are a little bit different could in the end actually help to, ironically, bolster those witnesses' testimonies, because I think everyone has some sense of understanding that no one remembers things 100%, right? Some little details are going to get fuzzy. No brain works that way. We are not exactly robots. And so if someone's story remains entirely unchanged, like on every single detail, to the extent that it feels like it has been memorized, that's where things can also kind of come apart sometimes. Okay, anyway, let's go on.
Weird, but she had some other things she had to go to, so she's going to come back some other day. Yeah, we have that to look forward to.
So what he's referring to here is that Detective Reyes is apparently, so she didn't actually finish her cross-examination on this day. So there was something else that came up for her, and so she's going to finish her cross-examination on a different day. I agree that that's very weird. It's pretty unusual, I think, and it's certainly not ideal, right? Because you certain things may get lost in the sauce, right? Between her direct cross-examination and then redirect, the jury may forget a lot of the things that she testified to on her direct examination, or even on her, earlier cross-examination before that point, when she eventually comes back several days later, the following week, who knows when, right? It's weird. It's weird. They might end up losing some momentum on her testimony, one side or the other. I don't know. And Tish in Tennessee says, I wonder if she could possibly be sick. That's not what it sounds like. It sounds like what he's saying is that there was a scheduling issue. Which could be the case. If she's a police officer, she may have some other duties that she has to get to. I'm not sure. But anyway, let's continue on.
Really wasn't that thrilling, the cross-examination. So then we got a couple of corroborating witnesses for Jane Doe 2. The first of whom was Jordan Ladd, actress, daughter of Cheryl Ladd. And she came on to talk about a conversation she had had with Jane Doe 2. Remember, Jane Doe 2 is the one who knew Danny socially. They went to this bar called The Well. He demanded her phone number. He then texted her, "You're coming over, bring a bathing suit." She said, "No, I'll come over, but I'm not bringing a bathing suit."
Right.
Got to the house, gave her a glass of wine, made
Yep.
her suspiciously intoxicated.
Yep.
Ended up, she claimed raping her in his bedroom, really violently.
Yeah, hers was like the worst testimony from what he said.
Jordan Ladd testified that like the next day, and at the time, she and Jane Doe too were best friends. They're both actresses, both in Hollywood. Jordan Ladd had taken a couple courses, but she said she wasn't a Scientologist. She wasn't part of the Scientology crowd. The next day, Jane Doe too had told her about this. And, with the details. I mean, many of the details were there. Not everything. It was a short conversation, but she said Jane Doe too was really extremely upset.
And that's important, right? Because the main argument in the Masterson case is the defense is saying, look, these are women who got together and cooked up a story, right? They tried to make make up a story about him to try to take him down because they had some kind of personal grudge against him. They didn't like him. They wanted to take advantage of a movement. There are all kinds of possible motivations for doing that, right? Similar allegation to what Marilyn Manson says about Evan Rachel Wood, Elma Gore, and all of those other women. So the thing is, when these various alleged victims have told the same story to other people, matters, right? Same thing with the Weinstein case as well. And so here he's saying that Jane Doe too told someone immediately the next day, her best friend, and gave a lot of the details that are very important details. Leaving some details out, jury might say that that's, a little bit less convincing for them, but maybe not, right? Where the most important details are there, jury is going to look favorably on that. And that ultimately undercuts the argument by the defense saying that these women all basically got together to make up the story against him so that they could all just come out and allege these things against him.
Now, what I found most interesting about her testimony today was she, described that they were absolute best friends in 2003, but then they weren't friends for years. They had some kind of a falling out. They weren't friends at all in 2017 when the news broke that Danny was under investigation. And Jordan said she saw those headlines and she wanted to contact the LAPD and say, I know something. She told me back in 2003. I thought, you know what, that really speaks to her integrity and credibility, that even though she was no longer a good friend at all with Jane Doe too, she felt she needed to talk to law enforcement about this. Then Cohen did his best to make, of course, what he always does.
Hang on, before we get into what Cohen said, the only thing that I'm thinking about this part here, right? About her Jordan no longer being a best friend of Jane Doe too, is it unfortunately, for the alleged victims in this case, it does remind me of Depp v. Heard, right? Where Amber Heard's friends were no longer her friends for some reason that was never presented to the jury, right? It was just like the jury was supposed to just accept that these friends were no longer friends, right? And so therefore they didn't have any sort of reason to lie about the things that they say happened that corroborated Amber Heard's testimony in various ways. There was a lot that didn't corroborate, of course, and that's why Johnny Depp ended up winning. But there is always a possibility, I can't help but put it out there, right? And it's not to be, not to be anti-alleged victim, but there's always a possibility that there's always a possibility that they might still be friends. I don't know. This is us getting it, of course, getting a retelling from Tony Ortega. So maybe if we were to be in the courtroom ourselves and to view the testimony ourselves, we'd be able to see whether or not that appears credible or not. So yeah, Nicole Christine reminds me of Rocky and Io. That's exactly what I was thinking. And that's not to say that every single case that we look at in the future is going to be that, right? We're not going to take Deputy Heard and assume that every single case is like that one. That's not what we do. It's not what we're about here. But that is a possibility, unfortunately, and we have to be mindful of that. So, but Tony is pretty. He seems pretty convinced based on what he saw in the courtroom. So, I will give some credibility to. I will give some credibility, some I should say deference to Tony and his impressions in the courtroom as well. I mean, because we can't see them ourselves.
I don't blame him. I mean, he's doing his job as a defense attorney. What he needs to do then is try to make it sound like there's something unseemly about the way it happened. That Jane Doe 2 talked to you before you talked to the detective. He's always raising the issue of that timing, and of course that's what he needs to do. That's what he needs to do.
That is his job.
But I thought she came through that pretty well. I mean, she seemed very credible that this conversation happened in 2003, and 14 years later, even though they weren't friends anymore, she wanted the LAPD to know about it. So that I thought that was pretty strong. She was then followed.
So, and I will say, if that is the case, right? If it is in fact the case that they were best friends when Jane Doe 2 told her about it back in 2003, and that they had a falling out since then, and that even with that falling out, that her friend Jordan, then wanted to come forward and tell the police about what she knew about that particular case, that is very, very good for her credibility. And that is very, very good for Jane Doe 2's credibility as well. That is very, very bolstering. So if the jury was convinced by Jordan's telling of those events, then that's a major plus for the prosecution, I think.
Jane Doe 2's mother. And she was older, and she's been through some ill health, but she looked, okay today. But she definitely was, elderly and not, a slight woman and a little frail maybe. Did her best. She was obviously very nervous. So was Jordan Ladd. And she struggled. She struggled to remember everything that was said 19 years ago in a 2003 conversation. She had apparently been told something by her daughter just a day after she told Jordan Ladd. And,
and this would be further corroboration as well, having the mom then testify after Jordan Ladd, right? To say that there are things that my daughter came to me and told me about, with regard to the things that she said happened. Sorry, excuse me. So obviously with having a mom involved, there is a possibility of bias, right? Because every mom cares about her daughter, regardless of the strength or weakness of that relationship. There is love there. We talked about that a bit in the Weinstein case, right? We had a daughter testifying to what her mom revealed to her as a teenager, about her experience with Weinstein. So I would imagine on cross-examination, that's something that comes up as well. But again, it is helpful. It is helpful that she told her mother, she told her best friend, like the day after, 2 days after this all happened, because that immediacy helps her case.
Oh, and of course, on cross-examination, did his best to kind of highlight that she couldn't remember every detail, that she struggled to remember some things. She couldn't even remember some things she told Detective Vargas just 5 years ago. But what I really was impressed by her was that she said, look, things are vague for me. I have heard things since then, and I can't remember everything from the 2003 conversation, but I remember 3 or 4 things very clearly. And I thought, you know what? That's how memory works. Right? Think about it in your own life. Think of a conversation you had 19 years ago. You won't remember the details, but there's going to be some nugget that you swear was part of that conversation. What did she say was vivid in her memory about that conversation? That Danny was coming at her from behind like a jackhammer, relentlessly, and that it was painful. That she told him to stop, and he wouldn't stop. And that it was so awful, she threw up in her mouth. These are the same details Jordan Ladd remembered. And that idea of that she told him again and again, stop, 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 and he wouldn't. That's the key. That's what makes it a rape. So
Yeah.
I thought she did well trying to convey that she admitted she couldn't remember everything from a conversation that long ago, but those details stood out for her all these years later. Now I want
And that sincerity can do quite a bit for a jury, right? To say like, look, I know it's been years. I know that I don't have a full recollection of what my daughter told me all those years ago, but I do know this. And that sincerity can definitely come across. It can definitely come forward. The jury can pick right on up with that, right? Um, so yeah, and like I said, memory isn't exactly robotic. People have at least some understanding of that. Um, so she may come across as a fairly credible witness with all of that said.
to say something about Cohen's cross-examination because I've seen some comments at the website about how he maybe is coming across as inappropriate or something. I disagree. I think that his job as a defense attorney is to ask tough questions. He has done so politely. He has done so pointedly. But I think in general his behavior has been fine. I think it's been a little ineffective. I think he's focused on very minor details. And somebody will tell me he's setting things up for later. I understand that.
And it could be that those minor details are just because that's all he has in his case, right? So, that may have less to do with the attorney than with the facts of the case, right? By the way, Singer McSquirrel, thanks so much for the super chat. Says, hey, you watching but not in chat, please hit like. Thank you, Secret McSquirrel. Really appreciate it. All right.
But I do not have a problem with his style and the way he's talked to people.
And obviously, I can't see what he's doing in the courtroom, but someone like Tony Ortega, who, like I said before, is very passionate about this case, right? It definitely comes through. He definitely comes across as an advocate for the alleged victims here, right? So I trust him saying that, right? Saying that defense attorney Cohen has been very professional, very polite so far uh with all of the witnesses that have come forward. He's just basically doing his job, so to speak, right? Um and that's the case. Sometimes a litigator just has a tough job, uh and they have to take a tough stance and put people in very uncomfortable positions by asking them tough questions and putting them in the hot seat, right? It's just the nature of the job sometimes. Litigation is all about trying to poke and prod and find weaknesses in arguments so that you can get to the truth with a capital T. So I do agree that my personal default is that an attorney that is doing things that sound like they're being an a-hole, more often than not, usually what they're doing is just trying to do their job. Let's continue.
Until he was talking to Jane Doe to his mother today.
And that's a possibility here
This
too.
was the first time in the trial I have felt he came across like he was bullying a little old lady. It got a little bad. I was wincing, and I thought this can't be coming across good to the jury. I felt like he was trying too hard to push her that she couldn't remember things, and in particular, he was going after the word rape. Your daughter didn't say rape. No, she didn't. And she only started using the rape word recently. Yes, she did. But he just came across as it was unkind. It was cruel. And again, I really don't think he's been like that throughout this trial. I think this was the first time. And then on redirect, she got to explain why.
Okay, hang on. Before he gets into redirect, I do want to say relatives of alleged victims are some of the more difficult people to cross-examine, right? Talked about this for related to a lot of different cases. especially where there's like, a murder case, right? And you've got a mother, father, a child, an aunt, an uncle, somebody who's testifying about who that person was during their life before they were killed by the defendant. Those are difficult people to cross-examine because there's a lot of emotion there, right? Usually that's what they're there for, is to provide emotional color for the jury. In this particular case, the mom is doing more than that because she's also corroborating what her daughter is testifying to by saying, yes, she told me the same thing 2 days after it happened. And so she's a bit more than just an emotional witness here, right? To give that sort of, like I said, emotional color. But at the same time, she still is someone who is very close to an alleged victim. And if the attorney comes across like they are trying to bully that witness, there is a very big risk that can backfire. That can totally backfire from the jury, because the especially if the jury is so far, if it feels like they are so far siding with the prosecution and saying these victims are pretty much telling the truth here, I think the defense kind of bullying a witness who isn't one of those alleged victims, but is somebody who is very close to them and cares about them quite a bit. And especially as somebody who is a little bit of a vulnerable person, like a little old lady, that's often not a very good look. So I understand what he's saying here.
Why about the word rape, and this was probably,
So now on redirect,
me, the most, the thing that came through the most today as something I could relate to, somebody explaining themselves, where the defense has tried to be very narrow. Did you say this? Did you say that? Finally, Ariel Anson asked Jane Doe 2's mother, well, what did you mean about the word rape, not using the word rape? And she explained, in 2003, I still had the idea that a rape was something that involved some man holding a gun to your head or a knife to your throat. I didn't realize it was just a thing about consent. I've learned that since then. She said that and was just like, wow. That just seems so credible and clear.
And sorry, I will say, on this note, I really want to know the age ranges of the jurors, because some of them, if they are a little bit older, that is probably something that will resonate with them quite a bit. And to say, like, yeah, the public conception of that definition has sort of changed over time. I had a different understanding before, because that's kind of what was generally accepted before as the definition of this term. That's a possibility. If you've got younger jurors, that might not hit as well as it does for Tony, for example, because they might say, like, no, like this is all about no means no means no means no, right? Like that's the definition, and that's what's been hammered into me since youth, so it depends. But I will say, even still, I think that someone who is younger might be able to understand someone who is older, who is coming at it from a different perspective and a different time of their life, and a different time culture, I guess is the term for it. I don't think that's the term for it. I'm just kind of making up phrases at this point. But you know what I mean, right? Like you can understand that, like, somebody comes from a different era, right? And thinks of these things a little bit differently. Okay. All right.
So I give her credit because she was having a hard time on the stand. It's not easy, I think, being older, and it's your daughter, and I give her credit for kind of standing up for herself at that moment. So that was the big moment of the day. We'll be back in court tomorrow. I don't know if it's going to be a full day. I think we're going to hear from a couple more, a DA investigator and possibly an expert tomorrow. So Sorry about the noise. We're live, people. We're outside a bar. But it seems like every day, I thought, there weren't big names today, but it was still very interesting. As far as what we've got left, after tomorrow, I think the prosecution's basically only left with 2.5 days, Tuesday, Wednesday, and Thursday. Are they going to get Lisa Marie Presley and Marty Singer in there? I don't know. I hope they do. Those are pretty interesting names. Well, we'll see. Thanks for hanging out with me. I love the comments I'm getting. If you guys appreciate the transcripts, I'm typing as fast as I can. Oh,
yep. Definitely appreciating those.
If you're seeing this on YouTube,
for sure,
you're a day behind the rest of us. Please sign up for the free emails at tonyortega.substack.com. You'll get my reports from the courtroom. They're so
linked in the description.
They're crazy. I sent out 4 of them today.
All right.
From a tavern in Los Feliz. This is your proprietor signing off.
All right. So that is from, let's see here. Oh, that is from day 14. Yeah, day 14. Okay, let's go to day 15 now. And we will get Don Baca. Tony's doing a good job. He is doing a very good job. He's doing a fantastic job. I certainly appreciate his efforts because it is let's see here. This one. Okay. He's given so much more detail than what we can get pretty much anywhere else. Alrighty. Okay. Here we go. Day 15. Back at the courthouse now.
The ground bunker.
Oh no, this one is quiet. Hang on a second. This one is so quiet again. Let me boost this volume again. Let's get this way up here. Okay, let's see here.
Ryder.
Whoa, that's a bit louder. Hang on. I think that might be a little bit too high. Let's try this. Let me know if this is okay for you guys.
It's Friday afternoon. Full day of court today. And if you ask the other journalists, they would tell you that not much happened today. Well, they're wrong. It was a full day of stuff. If you knew what was going on. Let's start with the morning's big news items.
All right, we got thumbs up in the chat. I think the sound is good.
After 3 weeks, the New York Times finally weighs in and says, hey, there's a Danny Masterson trial going on. And it's based on no testimony at all. It's just based on reading documents.
I agree. He has a great personality.
But wouldn't you know, they use the partial names.
Yeah.
And that's the other big news item today. You may have seen my story this morning where I talked about these partial names and how I've been spending more than a year trying to talk to news organizations about how using those partial names is a complete violation of their policies of naming sexual assault victims. It makes no sense. Just because they're using these partial names in court doesn't mean these news organizations should be using them in their stories. It's just, I don't know, it's maddening. But as I said this morning, I found out I'm not the only one sending emails and trying to point this out to news organizations. A law firm started doing it. And once I realized which law firm that was, I realized it was a big story. Yes, David Boies, I had heard, had an interest in this case, and he is now representing Jane Doe 2 and Jane Doe 3. And they said they're representing them just for their rights during the criminal trial. Okay, whatever you say. I have a feeling there's going to be a change in the civil case, but I do not have that nailed down. Anyway, I know many of you pointed out that David Boies has got lots of baggage with the Theranos thing and Weinstein and all that. But here's what's important. David Miscavige cannot be happy that one of this country's most well-known litigators has gotten himself involved in the Danny Masterson case. That's really what matters. So I'm interested to see what happens with that later on. So that was the big news this morning.
Okay, let me first say, so for anyone that doesn't know who David Boies is, he mentioned the Epstein case, he mentioned the Theranos Elizabeth Holmes case. So let me give you a few details about David Boies and some of the stuff that he's represented. So he represents some of the Epstein victims, including Virginia Roberts Jeffrey. In 2015, he represented Bob Weinstein and Harvey Weinstein in renegotiating the Weinstein's employment contract. So he has represented the Weinsteins. Obviously, this is an employment contract that's different from the SA case kind of stuff that we've been talking about on this channel. So, to me, a lot of people have worked for Harvey Weinstein, right? It doesn't necessarily mean that they are complicit in the things that Harvey Weinstein did. Yes, it was an open secret that he was doing things to people. Hello, Holmes. That he was doing things to so many of these women in Hollywood. Um, uh, but the reality is that there were so many people that, quite frankly, basically had to work for him, right? Okay, hang on. Let me move this over so you can cut. Oh, yeah. You want to come cuddle? Okay, Holmesy. So there is that. In February 2016, he agreed to both sit on the board of directors and act as attorney for Theranos, Elizabeth Holmes' company, which is now defunct, and there's all kinds of litigation around that. And she's been convicted of all kinds of stuff related to that. So this required him to represent both the company as its lawyer and the investors as director on the board, which is, if anyone is remotely familiar with with that whole situation, you understand that there was a conflict between the investors and the actual company itself at a certain point, right? Um, because there was allegedly fraud. So it's a very gray area in terms of like the conflicts of interest in terms of his role there. So it's interesting, right? It's, to say the least. That's one way of putting it. Um, yeah, he pulled some shady stuff there. That is the implication there with his position, at the very least. Other stuff, he's also represented big tobacco companies. um, so like when we think of like lawyers who take on cases that they really passionately care about, that's not him. Maybe, perhaps, I don't know. Very shrewd businessman, knows what kind of clients will be paying a lot of money. Hey, those lawyers have to exist as well, right? But for me personally, the one I really don't like the most is in March 2010. He represented Jamie McCourt in her divorce from the LA Dodgers owner Frank McCourt. If you've been following, you might recognize that I am a massive Dodgers fan, and that particular divorce basically like destroyed the franchise for a lot of years until like it took like a group of very, very wealthy co-owners to come together and buy the team and turn everything around, and then they started to like make the postseason again and all that kind of stuff. um so uh yeah, so he's had a very interesting career in terms of like who he's represented and what kind of cases he's been involved in. um and it's very, very interesting. But what I do understand about his role in this particular case is not just that he's apparently only representing the women in terms of their rights for the way that their names are published out in the media, which at this point it's like he can't put the genie back in the bottle, right? If the media has been talking about these women in a particular way, they've been talking about them in a particular way. And also I see a question in the chat about the kitty's name. This is Holmes, named after Supreme Court Justice Oliver Wendell Holmes Jr., who had the greatest whiskers in the history of the United States Supreme Court, and also was a fantastic jurist. So anyway, Holmes equally believes in the marketplace of ideas. He's often chattering and talking a lot. Thankfully, right now, he's just relaxing and being super cute and cuddly. But anyway, as I was saying, so not only is it just that he's apparently just representing them as to their rights here, for their names in terms of how they're published, he's also doing it pro bono. And that's an interesting point that Tony made here, is that like he's like, maybe maybe he's just doing it for this now, or maybe this is like a test run or a trial run to sort of convince them to hire him for the civil case, right? Because there are 4 women and one husband of one of the women who have a civil case against Masterson and against Church of Scientology for retaliation for coming forward and for making these allegations against him publicly, talking about harassment, stalking, intimidation, intimidation of family members, killing household pets, which actually it makes me really, really, really sad. But anyway, so it could be that this is just a little bit of a free period, like trial run, like test us out and then you can start paying us later. I don't know, because it's interesting. It is interesting to see like what his angle is. And it's a very interesting point that Tony had here about that. Right, Holmes? You got anything to say? No? Okay, cool. We'll talk later. Okay. Back to Tony.
We started testimony, and today's first witness was Dr. Mindy Mechanic, who was an expert on sexual assault trauma.
Interesting.
She spoke fast. I did my best. I had to paraphrase some of her things. But I wanted to point out a couple things about what she said. She was a blind expert. What that means is she did admit she had some slight understanding of what this case was, but she purposely stayed away. She didn't talk to any witnesses. She didn't talk to any of the victims. She would purposely kept herself in the dark about the specifics of this case so she could just come in and testify in general about what research shows women will do. And it was specifically women. I know men can be the victims of sexual assault, of course, but specifically how women react to being sexually assaulted by a partner, not a stranger, a partner. And she was very effective, I thought. And I asked around, other people thought she was very, very as well. That, she presented testimony based on research that it's normal for there to be post-assault contact when the perpetrator is a partner in a relationship. It's not unusual. And in fact, and then as far as, interviewing somebody over time, she said it would be suspicious if their stories didn't have some slight differences over time.
Makes sense.
Now, she's not talking about contradictory statements like he was wearing a brown shirt and then a year later saying he was wearing a blue shirt. Not that, but that some details will be included in one telling and some in another. And so she, these things did have relevance, especially with the cases of Jane Doe 2 and Jane Doe 3, I thought. So, and again, she's just an expert. This is not direct testimony about things that happened. But then came the cross-examination.
Which, this kind of testimony is going to be necessary in a case like this. Harvey Weinstein, they also had an expert that testified for the prosecution about this kind of trauma as well. And you're going to need it, right? The defense is also going to put on their expert. So it's going to be, there's always inevitably in a case like this, there's going to be some kind of battle of the experts, right? They may testify to memory issues, kind of like what the Weinstein expert is expected to testify to as well. So it's interesting to me that she was a blind expert witness here, because she didn't actually analyze any of the people involved in this particular case. It's interesting because it allows the jury to basically line that up themselves, because it means that she hasn't done anything to even unconsciously align what she is saying to what anyone has testified to. Because there's always that possibility when it comes to an expert, right? When it comes to any witness, but particularly experts, because they are actually allowed to watch the testimony of other witnesses, unlike a lay witness who is not allowed to, because they are testifying to the facts of the case. And so if they're able to watch what somebody else testified, about, then they're able to kind of like meld what they say to what the other person said. Um, the difference with an expert is that they are allowed to they are allowed to testify to their opinions because their opinions have been basically verified through the rigor of the process of qualifying them as an expert in a particular field, right? And so that's why they're able to give their opinions. Those opinions are obviously limited to their area of expertise. Um, so it's interesting to me. And I wish that he had given us some more details about what exactly she said about that post assault contact when the perpetrator is in a relationship with the alleged victim. Um, but it does make sense what she said, that it would be suspicious if their stories didn't have some differences over time, right? Because the human brain, we're not robots, right? We remember things a little bit differently as time progresses. The question is, are those differences in places where they matter, or are they not? That's where the crux of the issue really is.
Examination. And it was done by Karen
So we're
Goldstein.
talking about
And she is a
cross-examination now.
sharp attorney, obviously really smart. But she comes off a little harsh. And instead of questioning Dr. Mechanic specifically on her statements about that might be related to this case, she was basically questioning the basis of all psychological research. I mean, that's what it was. Well, these studies you're talking about, they're based on self-reported data, right? And several times the professor was, well, that's the only way to do research. And let me say, I'm sure some people are thinking, oh, well, okay, Danny's a Scientologist, so of course they're going to question the psychologist. But keep in mind, because Scientology hates psychiatry and psychology.
I admit that was like my first thought.
Fury. All right, that's important.
That was also my first thought too, right? Was like, okay, like I understand that like Scientology views psychology as like enemy number one, right? Because they're like, it's like their greatest competitor, I guess. Or I don't know. That's how Scientology views them, at least from what I understand. So I had that impression too when when he first said that about like, oh, that they're trying to sort of like undercut psychology altogether. And I'm like, wow, like maybe someone at Scientology headquarters really is tied in really closely to this defense team. But it could also be that they just need to find some way of trying to undercut what this expert is testifying to, right? Because yeah, like we can see that in basically any case where there's an expert, right? They're going to try to poke at the process of how that research was done, right? How that research was taken, and any possible ways that somebody can manipulate the data that is used for that research, right? Because if it's garbage data in, it's going to be garbage data out. So to a certain extent, the expert is going to have that coming at them on cross-examination anyway. But that's a fair response. If, assuming that actually was a response, I'm guessing it was, because it sounds like he's not quite paraphrasing, but he's basically saying what she said in response to that um was that she said like that's how this kind of research is done, like overall, right? And if that lands in front of the jury, then yeah, it kind of makes the attorney look a little bit foolish, right? To say like, oh, well, you just don't believe in science, do you? So or you don't believe in psychology overall. And to answer a question in the chat, is the defense attorney psychologist or Scientologist? No, I don't think so. I I don't I don't think. I think actually when I had Aaron Smith Levin on the channel from Growing Up in Scientology, the YouTube channel Growing Up in Scientology, I think he said that they actually don't have any attorneys in Scientology. Like it sounded, the impression that I had was that they don't allow people to become lawyers in Scientology, but I don't know if that is the case or not. But my understanding is none of the attorneys that are representing them right now are actually Scientologists. Okay, all right. Let's continue on.
Keep in mind, the defense has only listed 4 witnesses for when it's their turn. Bree Schaefer's one of them. The other 3 are all experts, and 2 of them are psychologists. So I'm sorry, it was just sort of like amateur hour and it was a big difference because the case has been, very serious, and Cohen's been very good on cross, but this was it just did not go down well, I didn't think. However, one journalist brought up to me at the break that Goldstein had done one thing that she thought was really interesting. And that was Goldstein at some point, because she kept saying, don't these people who take part in studies, couldn't they be lying? And, Dr. Mechanic was saying they have no motivation to lie. They're not being prosecuted or something, right? So there's no motivation to lie. But then Karen Goldstein saying, yeah, but couldn't they be motivated by money? And Dr. Mechanic was like, I suppose. Couldn't they be motivated by revenge? I suppose. And the journalist said to me, this is the first time the defense has mentioned a possible motive for the women not telling the truth. And she said, and the reason why she said that was that it struck her that Cohen hasn't done that. Well, look, the defense hasn't had its turn yet, but she's right that it seems like the preliminary hearing, for example, a year ago, Mesereau was much more forward about the idea that they're trying to prove it. These women are lying, that they're colluding, that Leah Remini's behind it. With Cohen, there's just never any sense of, well, what's your theory? So I thought that was an interesting observation by this journalist.
Okay, so I think I find that very interesting as well. And generally speaking, when you have a theory of your case, well, at trial, you should have a theory of your case, right? Because you want to establish a framework through which the jury can view all of these facts, right? You want them to accept your framework. That's your theory of the case, right? The theory of the case for the prosecution is all of these women were victimized by Danny Masterson. He did these terrible things to them. He did similar things to them in terms of like what he would do is he would give them 1 glass of red wine. Then they were suddenly randomly completely intoxicated. Then he would take them to the bedroom or to the shower and blah, I'll do all the things. So that's their theory, is that he's basically like a serial SAer, so to speak. The theory of the case for the defense, my understanding was that their theory is these women are lying, these women are colluding, these women are making a mockery out of the justice system by coming up with some scheme that is a complete lie and a complete fabrication against him just to try to take him down because they have some kind of a personal grudge. The problem with that is that we are now several weeks into this trial, and that hasn't been reinforced throughout. Tony mentions that the defense hasn't put on their case yet, but both sides are basically tasked with reinforcing their theory of their case with every single witness, right? That is how you put on a very strong case, is that you reinforce your framework with every single witness. And if this is the first time that the defense has mentioned a reason for them to collude or a reason for them to concoct a story out of nothing, to pluck a story out of the sky and call it real, that's the train may have left the station already for the defense at this point, because it seems like the prosecution has done a decent job of reinforcing these consistencies of these stories throughout time, and based on who they told and when they told them. And that has happened time and again. And before they all met one another, that I've said before, that already undercuts their argument. But if the defense hasn't been giving the jury like a planted seed, right, for a reason for these women to lie before this point, they haven't even, like, you could do that on cross-examination, right? Even if these women say, no, I didn't have that reason. Like, no, I didn't have a personal grudge against Danny Masterson. No, I didn't have, hatred for him because of XYZ. No, I wasn't trying to take advantage of the Me Too movement. It doesn't matter what they respond, right? Because you would expect a witness in that position to respond in that way. But if Cohen hasn't mentioned these potential reasons for them to lie, he has not been putting forward their theory of the case. Him or Karen Goldstein, the other defense attorney. So they may be losing out on opportunities for reinforcing their framework for the jury, in which case, by the time they get around to the defense putting on their own witnesses, it might be too late. The jury may have completely accepted the framework of the prosecution by that point. So basically, all of that is to say that, like, yes, the defense puts on their witnesses second after the prosecution, but they still have opportunities throughout the prosecution's case in chief through their cross-examination to get their story out. Because in cross-examination, they are supposed to ask leading questions. They are supposed to ask yes or no questions where they're essentially testifying and they're just bringing along the witness for the ride. So it's interesting to me that they haven't really done that. And it almost, I don't know. I'm kind of two minds about that, because on the one hand, as I said before, sometimes if you go too hard against a witness, it can really backfire. At the same time, sometimes when you have a particular theory that is an aggressive theory, and this is an aggressive theory, right? To say they are not only is this not true, but they got together to put together this whole story as a group lie. That's an aggressive theory. You kind of have to go hard on that theory in order for that to work. That worked, for example, in the Kevin Spacey trial, where they, starting with their opening statement, they were like, this guy over here, the plaintiff in this case, is a lying liar who lies, and like all of the things that he said, he's got all of these reasons for why he's trying to take down an acting legend who didn't do anything to him, and all of this happened so many years ago, and his memory can't be trusted, and he can't be trusted. I mean, they were pretty. I remember when reading about the opening statements in that case, and I was thinking, like, dang, like this is, they are really going hard against Anthony Rapp here. Like I almost felt like I felt kind of bad for him, because at that point I didn't know, where the facts were going to line up. So I felt a little uncomfortable with how aggressive they were being. But as the facts sort of came out through their evidence, they reinforced that theory with each witness, and they ended up winning that case. So sometimes when you take the less aggressive approach, it can end up going against you. If your underlying theory of your case is an aggressive one, you kind of have to go all the way for that in order for it to work. Otherwise, it looks like you don't believe in your own theory. So that's my thoughts on that.
So then, after Dr. Mechanic, it was time for Mariah O'Brien. I was very interested in this. I don't think the other journalists kind of understood who she was. She was married to Giovanni Ribisi, the actor, Scientologist, from a big Scientology family. And they have a daughter, Lucia. And you might remember my story from a couple years ago where she went on a radio program using a pseudonym to talk about her famous father wavering about Scientology. And I had actual members of her family confirming to me that it was Lucia, and the father she was talking about was Vonnie Ribisi. Well, I can tell you one person who wasn't thrilled about that story was Mariah O'Brien, and she let me know. So I don't know if she
Like
remembers
I
me
said,
today,
he's been
but
covering
anyway.
Scientology for decades.
So, with all
So
that
he's got
buildup,
so
I was
many
just very
stories
interested
here.
in what Mariah had to say. And what she talked about, she was just in for a very small thing. And that was in 2014, she knew Jane Doe 2 pretty well, had her over for dinner. Somehow the subject of Danny Masterson came up, and Jane Doe 2 blurted out that he had raped her, and she left. And I saw somebody in the comments say, that they were not friends after that. And I saw some of the comments say, well, Mariah's not much of a friend. But see, I think it's really what's important here is that, Mariah O'Brien had the guts to come into court today and confirm that episode in front of the Masterson family. I mean, she was part of that whole clique. So I give her credit for doing that. And I want to mention again, why is this important at all? It's just a minor incident. Because again, what the prosecution is trying to establish is that all the Jane Does had these disclosures and incidents well before they had ever heard of each other. So Jane Doe 2 in 2003 told Jordan Ladd and her mother about the incident with Masterson, this brutal rape, she alleges. And then in 2014, 11 years later, she blurts it out at Mariah O'Brien's house. Again, why that's important is she hadn't heard at all. Jane Doe 1, Jane Doe 2, Jane Doe 3 had no idea about each other being victims until 2016. So
that's again, I feel like I keep harping on this, but that's where this is important, right? It's corroborating the story to undercut this collaboration sort of conspiratorial argument by the defense. And that is an important point here that he mentioned about this particular witness, about Mariah O'Brien, that she was and I believe is a Scientologist. The fact that she has testified and she's confirmed this, there are those who have left the Church of Scientology who have said, and by the way, I feel like I always need to say this when I mention the Church of Scientology. It's when I say Church of Scientology, that's officially what they are legally called. It's not a judgment on whether or not they are a church. The things that I have heard about Scientology definitely sound like it's a cult. So, I have been familiarizing myself with Scientology. I would never presume to be an expert on it by any means, not by any stretch of the imagination. I am not a Scientologist. I have never personally met one other than through YouTube, talking to Aaron Smith Levin. And I've had some correspondences with a couple others that through email and whatnot. But uh everything that I have heard from folks coming out of the Church of Scientology that have left it has led me to believe that there's always a possibility that they will lie under oath, right? Because Scientology law is above common law, right? Like regular everyday law, right? The law that binds people in the United States. And so you can lie. There's this idea that people have put forward that Scientologists apparently possibly believe. I don't know this for a fact, but this is what has been relayed to me. That Scientologists are allowed to lie under oath in normal laws in order to serve Scientology law. So someone coming in and testifying to something that is potentially partially damaging to Scientology is kind of a big deal. Whether or not the jury has awareness of that, I don't know, because the court has limited how much Scientology talk there is in this case, although it hasn't been completely eliminated. I mean, the defense would have loved for it to have been completely eliminated, but it has been kind of necessary to a certain extent in order to give context to what these women say was the reason for why they didn't come out sooner to file police reports. Anyway, so whether or not the jury is going to pick up on that shade of understanding about this particular witness, about Mariah O'Brien, is I don't know, maybe another thing. Maybe that is something that they won't actually pick up on. But for us watching, folks that are familiar with Scientology a little bit at least, can have some understanding about that as well.
This again cuts back on the defense theory we've heard before about this all being cooked up and these women cooking this up together. Okay. So then we got to Detective Vargas. And he's the lead detective on the case. He took it over from Detective Reyes. And, I felt that Deputy DA Mueller had to walk kind of a fine line with him because they were going fairly quickly. They didn't want to go into every allegation. In fact, at one point, when he started to get into kind of a little detail of one of the Jane Doe's allegations, Judge Olmedo called for a quick sidebar, and after that, they stayed away from that. And I don't think they wanted to use Vargas to go over the whole case again, and so they didn't. And they also were careful about what they said about Reyes and him replacing her. But Deputy DA Mueller definitely wanted to use Vargas to kind of go after some things that the defense had brought up previously. We got, for example, a hint that what we've been told, that the Scientology witnesses all immediately lawyered up with Vicky Podboreski once this case got going. And they used as an example Sean Fabos, that Detective Vargas and Reyes and Vargas both had just not been able to reach the guy. And it turns out that he'd been lawyered up with Podboreski. And when Vargas asked her that he wanted to interview Fabos, she never even got back to him. So I thought that was interesting. Now, Fabos obviously did show up in the case later. I think that has something to do with the fact that a tape of him turned up, right? Anyway.
Interesting.
Probably the most interesting thing that Vargas talked about when he was being questioned by Mueller was at the very end. And I don't know how many of you recognize what was going on there if you look through the notes. Has Jane Doe 2 ever said there was strangulation? No. Has Jane Doe 3 ever said that she was smothered by a pillow? No. Has Jane Doe 2 ever said she was carried upstairs? No. Has Jane Doe 1 ever said she was spit on? No. What was going on there? Do you understand what was going on there? Again, the prosecution is trying to anticipate the defense theories about this case, one of which is these three women have shared information, they've compared notes, they're colluding, and so they've made their stories sound similar in order to produce this idea that Danny has a pattern, right? So what Mueller was doing there with Vargas was showing that there are all these dissimilarities.
Yeah.
That, Jane Doe 1 says she was smothered by a pillow, but Jane Doe 2 doesn't. That Jane Doe 3 says she was grabbed by the hair, but Jane Doe 1 doesn't. So I thought that was a little dramatic and effective right there. It was obvious to me that that's what he was doing.
That's good for the prosecution.
Then came cross-examination.
Okay, so before we get into the cross-examination, I think that is another effective way of the prosecution trying to undercut that argument by the defense, right? Their theory of the case, once again, is this collusion argument. And so if they are able to, through one witness, right, in one fell swoop, you have the attention of the jury, you go through each witness with one witness, you go through each alleged victim, I should say, and you say, did so-and-so allege this? Did so-and-so allege that? Did so-and-so allege this? Did so-and-so allege that? It is showing the diversity of these various claims in the details, because it shows that they're not just like a one-to-one overlap of each other, right? Like there are some overarching themes here, right? We're talking about a glass of wine that may have been drugged and then getting tossed into a jacuzzi or a bathtub or a shower or, and then a bedroom. Like there's this sort of like tendency to follow a particular pattern in a specific kind of way. But then there are other details that come up that happen in each of these individual narratives, right? I mean, and the defense can try to say like, oh, they're just smart, right? So they're diversifying a little bit here and there to try to like make things seem a little bit different. But that doesn't work if these other details are consistent over time, starting from before they met the other alleged victims, right? So, very effective because normally, um, normally the attorney is only able to sort of like compile all of that into an argument, either in the opening statement where they can't argue, but they can present what they will be able to show the jury, and then at the very end for the closing argument, when they can kind of summarize all of the evidence that the jury just got to see and to say, look, everything here, look at this giant sphere right here. This is the case. And it looks exactly like we said it was going to look like, right? So this is for you. Take a look at it and come back and give us our verdict, right? That's essentially what they're going to try to do. And so it can be somewhat rare to have a witness partway through to be able to give that kind of a summary as well, but it's very effective if you can do that. So having Detective Vargas be able to reinforce that argument, it's going to be something that can help the jury sort of like remember and get reinforced on the prosecution's argument. So it's a good thing that the prosecution was able to do that. So, okay, let's continue.
Nation by Cohen. People, this is Friday afternoon, and it went on.
So now cross-examination of Detective Vargas.
I think everyone in the courtroom was drooping this afternoon. At one point, I looked over at the jury, and only about half of them were looking at Cohen.
That's not good for the defense.
He wasn't doing a bad job. He was going pretty quickly. He was boring in on small inconsistencies in the stories. But again, it felt kind of technical, and it felt minor, and to the point where, but he is finding things. Like, I will give him credit. He did with Jane Doe 1, got Vargas to say that she said there were these blackout curtains and the room was pitch black. So, and that's all he said about it. But what he's going to do on closing arguments is say, if it was pitch black in there and there were these blackout curtains, how could she see a gun? Right? That's what he's setting up. So, some stuff doesn't look obvious right now, but I can see where he's going. And, I got to give him credit for that. But other lines of question were kind of a mystery. Like with Jane Doe 3's 2 incidents, he's always boring in on this. There was the November 2001 incident that is the rape they're charging on, and the December 2001 unconscious sodomy. And it just makes you wonder, when is he ever going to explain how the prosecution chose one over the other is an issue. He just never gets there. It all feels like kind of a wind-up, because I would think from the jury's perspective it is, well, who cares how they chose one over the other? They're both horrible incidents, and one they've decided to charge him with rape on. It's frustrating that Cohen is doing this, and it's hard to see where he's going. Maybe it'll all become clear in argument, and then I'll have to, admit that that's the case. Could be. Who knows? All I know is it's Friday afternoon. We're so tired. Everybody crawled out of there.
Okay, so let me say something about that too. He's talking about that Cohen was getting some technical points. He, was talking about the blackout curtains and saying, like, the implication seems to be that, like, how could she have seen that he pulled a gun if it's so dark in there? The only problem with that is, if the jury's not paying attention, they're not going to have that evidence. I mean, it's technically an evidence, but it's not going to be in their recollection, right? So it could be that they have mentally checked out because they just they don't trust the defense, or they think that the defense has been reaching this whole time, and so they're like, what do you actually have here? What do you do I really need to strain my mind right now to pay attention to what you're saying, because I don't really think that you have anything at this point. It could be that, or it could just be that they are just damn tired. Like you said, it's a Friday afternoon. Everyone's exhausted. If half the jurors are not even paying attention, that's a problem for the defense, right? Because it means that what he is saying, his essentially the attorney's testimony, right? Because like I said, cross-examination, it is where the cross-examining attorney is essentially testifying, and they are pulling the witness along for the ride because they are leading that witness through the entire time. If the jury is not paying attention to you during your cross-examination, it means that what you have to say is not particularly compelling to them, because somebody, there are also many, many, many times where the entire courtroom can be basically dead asleep. And then you get to cross-examination of a particular witness and everyone wakes up because of what is being said and what is being talked about, because it is so compelling. That is always, always, always possible for that vibe to change on a dime. But if everybody was feeling exhausted, it's, I liken it to this basically this metaphor, right? When it comes to the jury, evidence has been presented in front of the jury, but nobody's paying attention. It's like a tree falling in the woods and nobody's there to hear it. Does it actually make a sound? Right? Like, does the jury actually, does the evidence actually make it in if the jury's not paying attention to the testimony? So, later on, if Cohen or any of the other defense attorneys, if they try to like refer back to this cross-examination by saying, hey, remember the blackout curtains that Detective Vargas was talking about, and this kind of thing, the jury might say, no, I don't remember. It's entirely possible that you may have some really great information that you're getting in front of the jury, but it doesn't make a damn difference because the jury has checked out, or the jury is exhausted, or the jury, for one reason or another, is just not paying attention.
Monday, there will be court without a jury, but they will be going over motions, so I'm sure there will be news. I will be here. Otherwise, I do have some good stuff for the weekend. Please keep checking your email. I will say once again, if you're seeing this on YouTube, you're a day behind the rest of us. Please sign up for free emails at tonyortega.substack.com. You will get my reports from court. I sent out 4 long reports today.
Do it.
Virtually everything said in court. I'm typing the fast I can. Well, they're in the park. They're setting up some kind of a concert right now. It's a lovely night. I'm going to have a nice Friday night with my friend Tim. We're going to go have something to eat. So, from the Clara Shortridge Foltz Criminal Justice Center, this is your proprietor signing off for the week.
All right. Whoops. Okay. So, all right. So that is that one. There's one more, guys. We've got one more. This one is going to be shorter than the last one. This is from yesterday. As he mentioned, there is no testimony from yesterday, but there was motion practice. So this is going to be interesting too. And I just want to reiterate again that if you guys are finding this stuff interesting, finding his information interesting, there is so much more detail that he leaves out of these videos because he's got to basically summarize things, right? But his Substack has way, way, way more detail than what he gets into here. So I fully encourage everyone to not only go and subscribe to his YouTube channel there to show him some love there, but also to go to his Substack and subscribe there. It doesn't cost money to subscribe or to follow on his Substack. You can support him financially. Obviously, that helps with this kind of stuff because I think he lives in New York State. So I think he is actually like traveling out to California for this entire trial, which can that can definitely add up, right? Yeah, by all means, please do support him because he is doing a massive amount of work here and we are all benefiting from this. Okay, one more video here. Okay. All right, let's do it.
Underground bunker.
I need to turn up this volume again. Sorry, guys. Okay, let's see. Oops. A little bit higher. Just a little bit. Little bit more. There we go. Okay, and boost that one. I've got multiple boosters here. Okay, let's go.
This is the proprietor. We're just outside the courtroom, outside the courthouse on a Monday afternoon. Not going to go into the park today. It's drizzling a bit. So I'm just outside the doors here. Short day, but a very eventful one. No jury, no witnesses, just Judge Olmedo and the attorneys. Well, we learned a few things today. The
Is it still low?
prosecution doesn't have much more time. They're really trying to get their case wrapped up in just a couple days, by Thursday afternoon. And we know they have to bring back Detective Reyes and Detective Vargas to finish up their cross-examination, which Cohen agreed he
Okay.
would try to speed up.
The volume
and
is
get done
up
quickly.
all the way.
So who's left after that? Deputy DA Mueller revealed that he wants 4 more people on the stand by
Okay.
Thursday afternoon. They are Jane Doe 1's mother, and she's particularly interesting because, as he revealed today, they not only want to talk to her, they want to enter into evidence some emails she sent the Church of Scientology after her daughter's incident.
Oh, interesting.
It's actually a really, really good story written by Amy Zimmerman at Daily Beast like 3 years ago. I'll link it at the bunker in the next day or so. Discussing what's in some of those documents. Really crucial stuff about how Jane Doe 1's mother put David Miscavige on notice that she didn't like the way the incident was being handled.
Interesting.
So Deputy DA
That would be
Mueller
interesting to
wants
hear.
to get some of that into evidence, along with, questioning Jane Doe 1's mom. Second, they want to interview Rachel Smith. I believe she's a Jane Doe 2 corroborating witness. I don't know a lot more about her. And then the 2 big ones. He wants to put on Lisa Marie Presley and Jane Doe 4.
Interesting.
Lisa Marie Presley obviously is a big name, will bring a lot of media attention.
Right.
But what we found out today from Cohen, defense attorney Philip Cohen, was that she provided some new statement. There was some new interview of her, just like in the last day or something. Well, as we found out earlier with a previous witness, that could mean something surprising. So
Interesting.
very interested to see what that is. If I had to guess, I'd say she might come Thursday. Final witness he wants to put on, Jane Doe 4. The day this trial started, on October 11th, I published material from the prosecution trial brief where I described Jane Doe 4's basic allegations. Her allegations are from 1996. She was an actress on a movie with Danny Masterson. There was a rap party. She freely admitted that she got herself intoxicated, ended up at his place, fell asleep on the floor, woke up later, and he was inside her. So the reason why they want to bring it in, because it has so many similarities to what the other women are saying. And as Deputy DA Mueller pointed out today, her allegations in August 1996 are just a month before Danny started his relationship with Jane Doe 3. So it's timely, he said.
Interesting.
The defense, Cohen, argued strenuously against allowing Jane Doe 4's testimony in.
Understandable.
I made a notation you might have seen in the piece. His voice sounded very different. I may be down on body language analysis, but there was no question from the sound of his voice. He really did not want Jane Doe 4 in. And Mueller, I have to say, he was straining too. Everybody in the courtroom knew that this was huge. And it was so important, Judge Olmedo decided she wanted to take a lunch break to look up case law before making a ruling. So again, pretty big ruling.
Yeah, I mean the reason why the judge is going to want to be careful about this is because California is a little interesting because of the fact that they do allow testimony by other witnesses who allege similar SA claims in a case that involves, a case like this that is a criminal case that involves SA, multiple SA, alleged victims. California allows for the introduction of other witnesses that aren't those alleged victims that are related to the charges in this case, right? That's why Weinstein, there have been a number of witnesses who have testified that are not related to the charges in his particular case. It's kind of a weird rule that California has. And it kind of stands in opposition to the normal rule against character evidence, right? Because character evidence, if you're not familiar, is basically where the prosecution tries to introduce against a criminal defendant. And this rule also exists in civil law, but where the prosecution tries to say, let's say it's a burglary, they can say, oh, well, so-and-so committed other burglaries in the past, therefore he definitely did this one. The problem with that is that logically it doesn't actually connect, right? Because just because somebody has committed just because someone has done a wrong in the past does not mean necessarily that they are guilty of doing that same wrong in this case, right? They might just be getting blamed for this just because somebody thinks, oh, well, this person definitely didn't learn from their mistakes. That is totally a possibility, right? Like the law also believes in the possibility that someone can learn from their mistakes. So this idea that just because somebody has done something in the past now means that they have done it in this particular instance, it is not a reliable way of putting on evidence for these kinds of cases. That is considered impermissible character evidence. That is different now from habit, where you can say that that someone does something routinely enough, that they do it, often enough, that it has become their habit. It is something that they can reasonably be expected to do on this occasion because they always do it. You could say, for example, someone every single day, when someone wakes up in the morning, they turn off the alarm on their cell phone. They scroll through Twitter or Facebook or some kind of social media. Then they eventually wake up. Then they go and they brush their teeth. Then they get dressed. Then they have breakfast. Then they walk out the door and they go to work. Right? Like this is a routine habit that you can establish over time, that they do this every single day because this is what they've done every single day for an extended amount of time. Right? So that's different from character evidence, where you say like, oh, well, they did this on one instance or two instances or even three instances in the past, therefore they must have done it now. But in these kinds of cases, like I said, California has basically, it's almost like an exception to this kind of a rule when it comes to an SA criminal case. But at the same time, there is a risk, right? There is a risk that this is, just introducing more past behaviors or past allegations of behaviors to try to trick the jury's logic, so to speak, to make them think, well, they did this a bunch in the past. They definitely did it this time. They'll continue to do it in the future. So that's why the judge is going to take something like this very seriously about whether or not Jane Doe 4 is going to be able to testify, right? Because Jane Doe 4 is not related to any of the charges. Jane Doe 4, I think, was going to be, but I remember there were like one or two other alleged victims where the prosecution dropped those charges because of, I think one of them had to do with the statute of limitations issue, and then another one had to do with just the amount of evidence that was available, that they thought that maybe they would not be able to actually win on that particular case. So anyway, let's continue on. Enough with my explaining on those issues.
Bedside, Cohen had said, he kind of said a couple different things, but I definitely got the sense he's willing to limit his
experts. He's listed 3 experts, 1 toxicology, 2 on memory, and it sounds like he's willing to call
Toxicology and memory. That's
only
interesting.
2, only 1, maybe none. I think he's interested in getting this thing done with 2. So
Interesting that he has so few
after
witnesses.
lunch, we came back. Judge Olmedo had an arm full of documents, case law, stuff she'd looked up over the lunch break. She asked them if they had anything else to say. Cohen, at that point, kind of, I don't want to say threat, but he let her know if she's going to allow Jane Doe 4 on. Because the reason why, I'm sorry, I should have said this at the beginning. Way back on October 10th, I think, maybe it was October 4th, Judge Olmedo had ruled that she wasn't going to allow Jane Doe 4 in the prosecution's case in chief, primarily because of the time-consuming nature of it. She's trying to keep things efficient.
Makes sense.
And so now Judge Cohen, after the break, before she could issue her ruling, said, look, Judge, if you allow in Jane Doe 4, I'm going to have to call back Jane Doe 2 and one of the detectives. In other words, he's letting her know it's going to be a huge waste of time, which speaks to her original ruling.
Which, and that might not be, he might not have an improper reason behind that, right? Because Jane Doe 4 might bring up certain testimony that changes the kind of questions that the defense would have asked Jane Doe 2 and Detective Vargas, right? It could possibly change their strategy on what they would have asked him. They may have left out some questions that they would have asked them if they had known that the prosecution intended to call Jane Doe 4, right? So you know, he kind of, you can tell that Tony's like, he's like, it's kind of a threat, but like I don't want to necessarily call it a threat. Like it's more like a warning to the judge, like I'm going to need to call these people. So if you really care about efficiency, if you really care about this running smoothly and us all getting out of here, you know, on a certain date at a certain time, like this is going to extend the trial because we need the ability to ask these other questions of these witnesses that have already been called up. They're going to have to get up here all over again. So that is a potentially legitimate response by the defense. Maybe, I don't know, or maybe they don't have very good reason to recall those witnesses.
Mueller had argued that the defense had opened the door when it kind of changed its approach from what Mesereau had been doing before. Mesereau had argued that this was all a conspiracy by these women to take down Scientology, orchestrated by Leah Remini. Cohen has a very different approach. He's merely focusing on the statements they gave law enforcement. He's staying away from Scientology. But, and so Mueller said that was enough of a difference that Jane Doe 4 was more relevant and he wanted her in. Okay. So then Judge Olmedo started giving her ruling, and she cited a lot of case law about this time-consuming statute that she had ruled under before. And she also said, like Mueller, that the defense has changed its approach. And the thing that surprised her was that at some point on like October 22nd, Cohen had actually said they don't believe the November 2001 incident with Jane Doe 3 ever happened. And so the judges are saying, you know, this is a very different defense than we had gotten to see before. And she agreed with Mueller that this does open the door for Jane Doe 4 for them to show another pattern of a witness that's like the others. The other point that Mueller had made was that what the defense seems to be saying is that these women had something in mind, but then once they talked to the law enforcement people, it helped them cook up and embellish their stories to meet certain statutes to get Danny into a trial.
Oh shoot, I did not mean to do that, sorry. Oh god, where was I? Oh no. I think maybe here. interesting because we just heard like a similar thing in the Weinstein case, right? Of course, these two trials are happening at the same time. But that was the cross-examination of the massage therapist that just testified a few days ago, right? The cross-examination of that was like, okay, but like, what about California statute about like, overclothes, underclothes? Like, did you modify that because that way it would fit the statute, and so therefore it would consist of a sexual battery? That's interesting that they're saying essentially the same thing here by the defense, but interesting, but at the same time, it's I mean, I would expect it, right? Because there are only so many tools in the tool chest for the defense in this kind of a case. Okay. Hopefully I clicked this generally where we were before. I'm so sorry, guys, if I put this in the wrong spot.
Focusing on the statements they gave law enforcement. He's staying away from
Okay,
Scientology.
a little bit.
But and so Mueller said that was enough of a difference.
Yeah.
That Jane Doe
Okay.
4 was
Basically.
more relevant, and he wanted her in. Okay.
Yeah.
So then Judge Olmedo started giving her ruling, and she cited a lot of case law about this time-consuming statute that she had ruled under before. And she also said, like Mueller, that the defense has changed its approach. And the thing that surprised her was that at some point on like October 22nd, Cohen had actually said they don't believe the November 2001 incident with Jane Doe 3 ever happened. And so the judges are saying, this is a very different defense than we had gotten to see before. And she agreed with Mueller that this does open the door for Jane Doe 4 for them to show another pattern of a witness that's like the others. The other point that Mueller had made was that what the defense seems to be saying is that these women had something in mind, but then once they talked to the law enforcement people,
Right.
it helped them cook up and embellish their stories to meet certain statutes to get Danny into a trial. And that one of the reasons they want to bring on Jane Doe 4 is that even though she also spoke to law enforcement, even though she also spoke to Mueller, she doesn't have any of those elements in her story. So this was all persuasive to Judge Olmedo. I can tell you she had a very grim look on her face. When she did all this, she knew it was a very serious issue and the defense was going to be very unhappy with her. And, even after she made her ruling that Jane Doe 4 can come in, Cohen then immediately just like reiterated the same things he'd said before. And then he pivoted when she made it clear she wasn't going to change her mind. He pivoted to something kind of strange. Do you remember at the point when he was, he had been questioning, I think it was Vargas, maybe it was Reyes, and asked her, did Jane Doe 1 tell you she, that night at the restaurant before they went to Danny Masterson's house, that she had peed in the street? And I remember that made Judge Olmedo really angry, and she had cited California statute that you can't bring up a sexual assault victim's drinking or behavior.
Yeah.
He brought that up again today. He seemed to be saying that her previous ruling really didn't fit case law or something. It was hard to understand. Jeffrey said something to me as soon as we got out, and I thought it was very perceptive. Jeffrey Augustine seemed to be saying that it seemed to him that Cohen was kind of trying immediately to come back at the judge by saying, look, if you're going to allow in Jane Doe 4, then you got to allow me in that Jane Doe 1 peed in the street. I think there was something to that. I think there was a kind of...
Which that would go towards a rape shield law, right? Like it used to be the case in SA. I'm so sorry. I'm sorry, Tony. Okay. I think maybe that's a little bit better. It used to be the case that when you had R and SA cases like this, that the defense was able to bring in evidence about the alleged victim's prior sexual behavior, right? Like how loose was she, right? Because the idea was if she was a promiscuous woman on previous accounts, she probably consented this time around. And that fits along with the whole character evidence thing, right? Because now there are rape shield laws that say you can't bring up her previous activities because that has nothing to do with what happened in this instance. Like consent can be given, consent can be taken away in any instant, right? So it's right along with the same concept as character evidence, to say, like, just because someone has done something in the past doesn't mean that they did it in this instant. Just because a woman consented to multiple encounters with multiple partners in the past doesn't mean that she consented to this one. So trying to point to her peeing in the street, that is a potentially sexual activity, right? That can be taken that way. So that potentially falls under rape shield laws. And yeah. So I can see why that is problematic for the defense to try to bring that in.
Thing like, okay, judge, you just hurt my defense. You got to give me something. But she stuck to her gun. She said, no, it's irrelevant. It's, as Mueller pointed out, you can need to pee in the street even if you drink water.
Yep.
So they kept that out, but then they did continue. I started to send out the story, and they went back and talked a little bit longer. I hope you all see the addendum I added to the story. What they decided was that Jane Doe 4 will be able to testify to her first incident with Masterson in 1996, not the second one that took place a few weeks later. The first one was after the rap party. It was at Masterson's house. She says he picked her up, put her somewhere. She passed out. She woke up. He was on top of her, inside of her. The second was a few weeks later. He came to her house with a bottle of Jack Daniels. She felt suspiciously intoxicated and once again passed out, found him on top of her. I think it's a shame they're not going to allow that second incident in. But just the fact that she's going to come in and talk about the first incident, I predict it's going to be a pretty huge day in court. It is. Believe me. You'll see why. So that was our very eventful short day without a jury.
All right.
Here, and tomorrow they'll be back in at 10 a.m. They're going to discuss limitations on what Lisa Marie Presley can say, and maybe we'll learn something more about this mysterious interview she just did, I guess, with the DA's office. So that'll be very interesting. This tomorrow morning at 10 o'clock, they'll be talking about Jane Doe 1's mom and Lisa Marie Presley. And then the jury will be back tomorrow at 1:30 afternoon, and we'll get back to testimony. So we're getting there. We're getting there. Wow.
Right.
What a day today. You should have heard the tone of voices of those attorneys. They knew it was a big moment.
That's interesting.
All right. On a drizzly day here in Los Angeles, from the Clara Shortridge Foltz Criminal Justice Center, Ryder signing out.
Okay. So, all right. That is... that's the end of that one for today. Interesting stuff. So it looks like there are 4 more witnesses for the prosecution, and then it looks like 4 witnesses for the defense, unless they are able to convince the judge that they can recall a couple witnesses. Jane Doe 1, or was it 2? I can't remember now. Totally just listened to it. And then also I think Detective Vargas. So, interesting stuff, but it depends on what it is that the defense actually wants to ask the witnesses on recall, right? Because if the testimony that they want to get into isn't relevant to this case, then they're not going to be able to recall them. Interesting stuff. Also interesting that Leah Remini is not being called as a witness to this case, because she was very heavily implicated by the defense early on in their strategy here, right? I mean, it seems like they have had a shift in the strategy when Tom Mesereau was out and then Cohen was in as the attorney on this particular case, which may have an impact ultimately on how this ends up playing, right? Because if it seems like they're sort of straddling a theory but not fully committing to it, the jury might see that as them not believing their own theory. which if the attorney doesn't look like they believe it, how is the jury supposed to believe it, right? How is the jury supposed to be convinced by someone that they don't think believes in the thing that they are saying? Um, that's something to think about, right? Okay. Well, thank you everyone for joining me. I know that this is a bit of a longer day today. We had a few days on both of these cases to go through. This was definitely a lot to go through. So I appreciate everybody for joining me. I appreciate all of the folks in the chat, everybody watching, everybody liking the video. Thank you to the folks that also super chatted. And of course, last but not least, thank you to the mods as always for doing such a phenomenal job of helping to usher this wonderful community of people that is coming together to talk about difficult things, right? I saw in the chat people that were supporting each other through talking about some of their tough experiences that they've been through themselves. It's one of the most beautiful things that I love to see in this chat, is people supporting people and understanding that people come from different perspectives, and sometimes people carry their own experiences with them, and that impacts the way that they view these cases, the way that they view the world. And I love that, and I find that absolutely beautiful, right? Because we can all always learn from one another for sure. Let's see if there is anything that I missed. I don't think so. And as I like to say at the end of these streams, because we're talking about some heavy things, if you walk away from this feeling a little low, a little despondent, like you don't really have so much control about some of the darkness that is in this world, try to think of one thing that you can do to make things a little bit better, just to make this world a little bit brighter. Something especially that isn't necessarily something that someone else can repay you for, whether that's another human being or another animal, or something. I like to say, pick up the phone and call someone that you haven't talked to in a while. Tell them that you love them. Tell them that you care about them, and ask them how they're doing. Or be kind to a stranger on the street, right? Whatever you can do to make this place just a little bit better, is always a good thing. So, alrighty. Okay, guys. Thanks again. This has been a great experience, and thanks so much for joining me through this. And also, once again, shout out to Tony Ortega. If you haven't already, subscribe to his channel on YouTube. Watch his his Substack. Take a look at his Substack. He's got some really, really great material. So, okay. All right, guys. That's about it for me. And I will see you guys in the next video.